video?
I'm here, yes.
Stay right there. Stay right there. Ma'am, why are you walking?
I'm at work. I'm going to my desk.
Tell me your name.
Foundation Diamond.
Okay. Did you listen to and understand the rights, Ms. Diamond?
Yes.
And do you wish to speak to a lawyer?
No.
I can't hear you.
I said no.
Wait a minute. Why are you walking around? I need you in one place. Get to one place.
Okay, I'm in one place.
Stop now, please.
Mm-hmm.
All right. Do you intend to apply for funding?
No.
Counsel, why don't you state your appearance and tell me how much is owed?
Rebecca Austin for plaintiff, Your Honor. The total with June rent is $3,075.54.
Can you pay that, Ms. Diamond?
I could pay May rent.
How much is that?
Well, prior to today's rent kicking in, Your Honor, her balance was like $1,600 with the court costs.
So you're saying you can pay that, but you can't pay June?
Right, and I could pay that by the end of the week. And I could try to get it all done by the end of the week.
You're telling me you think you can pay all $3,075.54 by the end of this week?
That's my goal, yes.
Well, I know, but what's the likelihood you're gonna be able to do it is my question.
I really wouldn't know until Wednesday, but I know for sure I could take care of May rent.
What do you want to do, Ms. Austin?
Your Honor, I'm happy to give her an adjournment to try, and then we can come back in a week or two and.
So I'll adjourn this to June the 9th. And if you have it all paid, great, the case will be dismissed. If you don't, then I'm gonna have to give them a judgment, okay? We'll make it June the 9th at 10:30.
8:30, Your Honor, if we could, please.
June 9th, 8:30.
Okay, is that good for you, ma'am?
That's good, thank you.
June the 9th at 8:30. We'll see you here then. Thank you.
Can I get my total balance again?
Yes, it is $3,075.54, and that does include June's rent, because June's rent's due today.
$3,075.54. 54.
Okay?
Thank you.
Thank you. Hamptons versus Daryl Travis. 2502031. Is he here? There you are, sir. Your name?
My name is Daryl Travis.
Your Honor, we're going to dismiss this case. He paid in full over the weekend.
Good. All right. You're all set, Mr. Travis. They're moving to dismiss. Case dismissed. Congratulations. Temuco White. Hamptons versus Temuco White. 2502033. Is Ms. White here?
Yes, I'm here.
Good morning, ma'am. Your name?
Temuco White.
Did you listen to and understand the rights, ma'am?
Yes.
You wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Jeez, I need some more pens up here. Can you hand me some, please? Jeez, none of these are working. All right, do you waive your right to a lawyer? Or do you wish to speak to?
No, I don't want to speak to him.
Do you intend to apply for funding?
No.
All right. Counsel, your appearance and what is the balance?
Your Honor, Rebecca Austin for plaintiff. The total with the June rent is $2,925.21.
Can you pay that, ma'am?
Yes, I can, but I need to do it in two payments.
I'm sorry, I didn't hear you.
I said, yes, I can. I need to do it in two payments if possible. June 9th and June 23rd when I get paid.
What do you want to do?
Our two pay dates.
I mean, that's fine, Your Honor. If we can split that in half and give her those two pay dates, that's fine with me. I mean, I can talk to her and do a consent judgment or.
Why don't I pass the case? Why don't I pass the case? And you guys can talk in the breakout room when we're done with the rest of these, okay?
Perfect. Thank you, Your
Hamptons
Honor.
versus Jacqueline Terry, 2502034.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ma'am, your name?
Jacqueline Terry.
Good morning. Did you listen to and understand the rights, ma'am?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Counsel, your appearance and how much, what is the balance?
Yep, Rebecca Austin for plaintiff, Your Honor. The total balance, again, including June rent, is $2,804.62.
Can you pay that, ma'am?
I can pay May's past due balance. I can actually pay that part today, and I'll have to break up the remaining in 2 installments. The 11th and 25th.
I'll let you speak to Ms. Austin. I'm going to pass this one too, okay? So wait till we
Okay.
get through the rest of these. She'll go into a breakout room and speak with you, okay? Hamptons
Okay.
versus Lorraine Murray and Gary Pritt the third. Pritt the third, Lorraine Murray, 2502036. I don't see them out there. Oh, there you
Gary
are.
Britt.
Lorraine Murray.
Okay, I do have you both. Did you listen to and understand the rights, Ms. Murray?
Yes.
Mr. Pritt,
Yes, sir.
do you wish to speak to a lawyer, Ms. Murray?
No.
Sir,
No, sir.
do either one of you or both of you intend to apply for funding? Ms. Murray?
No.
Sir?
No.
Ms. Austin, your name and what is the balance?
Rebecca Austin for plaintiff, Your Honor. Total balance, including June rent, $2,641.20.
Can you two pay that?
I was gonna see if we can split up in 2 payments. On the 13th and the 27th.
Let me put you in a breakout room with Ms. Austin here when she's done with the rest, okay? You
All
guys
right,
can
thank
discuss it, see if you can resolve it. Thank you. Hamptons versus Brian Walker, 2502039. Brian Walker,
Your Honor, we're going to be dismissing this as well.
case dismissed, motion to plaintiff. All right, do I have Hamptons versus Chelsea Tavalette and Asia Jackson, 2502040.
Your Honor, we're going to be dismissing this as well.
Case dismissed, motion to the plaintiff. This is file number 2502042, Hamptons versus Robin Hay.
How you doing, Your Honor?
You have to start your video, please. Your name?
Robert Hay?
Did you listen to and understand the rights?
Yes, sir.
You wish to speak to a lawyer?
No.
Are you going to apply for funding?
No.
Ms. Austin, your name and the balance, please.
Rebecca Austin for plaintiff, Your Honor. With June rent, the total balance is $2,226.84.
Can you pay that, Mr. Hay?
I'm asking, I know that's including this month's rent I owe for previous month. I'm asking I have until the 30th to have balance paid in full.
Why don't you go into a breakout room and talk to him? I'll recall all of these, okay?
Yep.
Just be patient, sir. She's got a couple more, and I'm going to put her in the breakout room with you and others. Just wait right there. Thank you. Hamptons versus Andrea Smith, 2502044.
Your Honor, we're going to be dismissing this.
Case dismissed. Motion of the plaintiff. Hamptons versus Jasmine Weatherby, 2502045. Is Jasmine Weatherby here?
Your Honor, I've not had her check in this morning.
Could take a default.
Your Honor, Rebecca Austin for plaintiff at a request of possession only default judgment. Rent to retain is $2,195. There's $170 late fee for May for a subtotal of $2,265. Court cost of $176.54 for for a total judgment of $2,441.54.
Defendant failed to appear, the relief request will be granted. That is a default judgment of possession in favor of plaintiff against defendant. The writ date will be the 12th of June. 244,154 is the amount to be paid to save it from the issuance of the writ. I'll let you go into a breakout room with the rest of those people. Marsh Creek versus Charmaine Williams, 2501574. Mr. Butchart.
Good morning, Your Honor. Brian Butchart, P 66250 for the plaintiff.
Good morning. Ma'am, your name?
Charmaine Williams.
All right, what happened with your application for funding, ma'am?
I was denied.
You were denied. I'm sorry about that. So you can go ahead and tell me about your breakdown here, Mr. Butchert, and we'll go from there.
Sure, Judge. We actually already met in a breakout room this morning, and we do have a resolution.
Okay.
The breakdown is $5,367 in rent, $140 in accumulated late fees. That's two late fees at 70 a month. $170 in court costs, which brings the total to $5,677.
All right.
I've sent Ms. Williams a proposed conditional dismissal via email this morning. She's reviewed it, and I think she's agreeable. We've agreed that she's going to pay $1,500 on June the 9th, $1,000 on June 23rd, and then $1,500 every other Monday thereafter, starting July the 7th, until she's current.
I'm sorry, $1,500 by June 9th, $1,000 by June 23rd, and you said $300?
$1,500 every other Monday after that, and that'll start on July the 7th.
And what is the total amount of the balance of it's 5,677?
Correct.
All right. Why am I?
What is it? They gave me a example, I don't know how to turn it out. You gotta take that out.
Okay, so you got 5,677. And ma'am, he tells me you're going to agree to a conditional dismissal where this case will be dismissed now, but it's in contingent upon you paying $1,500 by the 9th of June, $1,000 more by June 23rd, and then $1,500 every other Monday beginning July the 7th until that balance is paid in full. Do you understand and agree to those terms?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to clean here and fill out a motion to set aside the dismissal. You also have 10 days to appeal. Do you understand that?
Yes.
Any questions at all?
No, I don't have any questions.
He has your permission to sign your name to that proposed conditional dismissal?
Yes.
Okay, anything else, Mr. Butcher?
Nothing further, Judge.
Have a great day. Thanks a lot. Good luck, Ms. Williams. Thank you.
Always a pleasure, Judge. Take care.
Thank you. You too. Okay. Zeal Credit Union versus Cindy Woods, 2404676.
Good morning, Your Honor.
How you doing there, counsel?
Doing well. How are you?
Not too bad. Your appearance?
Clarence Kennedy, P 88082, on behalf of plaintiff.
You run for Senate with a name like that.
Appreciate it. Yeah.
Okay. All right. What's your P number?
88082.
All right. Good morning to you. Do I have?
Yeah, right to the podium, right here.
Your name, ma'am?
Cindy Woods.
All right. What is this about, counsel? It's just what?
It's a unsecured loan, Your Honor.
And do you agree that you owe this amount?
Yes.
Do you want to go into a breakout room and talk to Mr. Kennedy and figure out a way to resolve it?
Yes.
So I'm going to have her brought to a device and she can talk to you.
Okay.
And then I'll put this file aside. And as soon as you're ready, you tell me that, okay? Fair enough? Okay, Mr. Kennedy?
Yep.
Thank you.
Your Honor.
Granite Televalley versus Nathan Albrecht. 2501710.
Judge plaintiff's attorney is in a breakout room with his last second hearing.
Yeah, I don't know if I want to get in the habit of
I know, I was only doing it on second hearings.
Boardwalk versus Christopher Nieberdowski, 2501960. Is Christopher Nieberdowski here?
He has not appeared, Your Honor.
Counsel on Boardwalk, you can take your default.
Good morning, Your Honor. Which case was this? Boardwalk?
Nieberdowski, 2501960.
Thank you, Your Honor. Good morning, Your Honor. Donald Osinski on behalf of plaintiff. With the defendant failing to appear, plaintiff would like to request a default judgment at this time. I am showing rent to retain as $2,320, court cost in the amount of $184.17 for a total due and owing today of $2,504.17. We'd like a date of June 12th to either pay or turn possession over or writ to issue.
What kind of late fees do you have on this?
On Mr. Niebre's, there was one late fee of $75. However, I did reduce that late fee down to $70 when I did the calculation.
Defendant failed to appear. Default judgment entered. Writ date will be on the 12th of June. The amount to be paid to save it is $2,504.17. Boardwalk versus Stan Young, 2502001. You can come on up here, sir, and tell me your name. Good morning.
Good morning.
Your name?
Stan.
Did you listen to and understand the rights this morning, sir?
No.
Okay, you have the right to apply for funding with a variety of different organizations. You have the right to speak to a lawyer. You have the right to a jury trial. You have the right to apply for funding. If you apply for funding, I'm going to adjourn this for 2 weeks and give you 5 days to make your application and to submit proof of that to the court. Do you understand all those rights?
Yes, I do.
Do you want to talk to a lawyer?
No.
Do you wish to apply for funding?
No. Can I ask why am I here?
Wait a minute. What do you mean, why are you here?
Because I haven't missed no rent. I've never missed rent. Literally.
They think that you have.
Oh, I have receipts on my phone. It comes digital when I pay it.
Counsel, what do you think he owes here?
Your Honor, I am showing, including June's rent, $1,703.01. Court cost in the amount of $184.17 for a total due and owing today $1,887.18. The last time that it was fully paid was back in April of 2020, April 25th, 2025.
Yeah, can I turn on my phone?
Yeah, you can turn on your phone.
I'm gonna show you all the receipts. And 1 month I paid twice because I had family members I had to take care of, and I paid because I wasn't gonna be at home, so I paid early twice in 1 month. So that's probably one that they're not seeing, and I have it on my phone. But I paid this month and every other month.
Let me do this. I'm going to put you in a breakout room with him. We're going to put you in a room over there and you guys can compare payments. I'm going to go ahead and pass this case. Now, there's a few others ahead of you, but I'm going to pass this case. He's going to take you to a breakout room or to a computer where you can speak to Mr. Osinski and compare your payments. How's that?
So, hold on. Can I say something, Your Honor? Will he be able to see my digital payments? That's why I run the phone, so you on it. So they can see the
You could put them up to the screen. I'm sure you guys can figure it out.
Okay.
You're going to go into a computer room, okay?
Okay. But I only have always see the security officers and you.
Okay, thanks.
Thank you.
So, Mr. Osinski, I'm going to put you in a breakout room with him, okay?
Yes, Your Honor. Thank you so much.
Do I have everybody ready on Granite Del Valle yet?
We should be all set, Your Honor.
Okay, good enough. Granite Del Valle versus Nathan Albrecht, 2501710. Counsel, your appearance.
Printing for the plaintiff, P 80491.
Where is Nathan Albrecht? Is he here, Lisa, Jennifer?
Judge, he was, let me just,
He was here, Your Honor, and I did speak to him briefly.
he's no longer in my meeting.
Tell you what, let's go to the next one. Christopher and Roger Cunningham. Granite versus Christopher and Roger Cunningham, 2501712.
Printing for the plaintiff, at this time, we move to dismiss without prejudice.
Case dismissed. Motion to plaintiff.
Patricia Pronick, Your Honor, on behalf of Christopher Cunningham.
Yeah, he just moved to dismiss, so we're all set. Chris Granite versus Amber Warren and Blake Warren, 2501716. Are the Warrens here? Mr. Warren, your name?
Blake Warren.
Ma'am?
Amber Warren.
Printing for the plaintiff.
What are we doing on this one?
I had a chance to speak to the Warrens, and they're not disputing the amount owed. I've got 2136.01 as far as rent to retain, 229.18 of costs for a total of 2365.19. We were wanting to do a consent judgment with a writ date of the 12th, and they've given me permission to sign that as well.
Is that right? Do you understand that, Ms. Warren?
Yes.
Mr. Warren?
Yes, I do.
So you agree that you owe 2365.19, I believe it is. Is that right, Mr. Ingram?
That's correct, Judge.
Agree to that, Ms. Warren?
Yes.
Mr. Warren, do you?
Yes, Your Honor.
You understand you have until the 12th to pay up or vacate. If you don't pay up or vacate, you have to, you're going to be evicted. Do you understand that, Mr. Warren?
Yes, Your Honor.
Ms. Warren?
Yeah.
Now, does he have, Mr. Ingram, have your permission to sign your name to that proposed judgment? Mr. Warren?
Yes, Your Honor.
Ms. Warren?
Yes, Your Honor.
I'm represented by a lawyer. You have 3 business days to come in and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Ms. Warren?
Yes.
Mr. Warren?
Yes.
Any questions, sir?
No, Your Honor.
Ma'am?
No.
Judge will enter by consent 2365.19, the amount to be paid to save it, and the writ date will be the 12th. I wish you both well. We'll send you a copy of the judgment. Thank you very much and good luck.
Thank you. Are we able to leave the?
You are.
All right. Have a good day.
Manatella Valley versus Kayla Williams and Tara Lynn Sargent, 2501718.
Printing for the plaintiff.
I see either one of them here. There you are, ma'am. Your name?
Kayla Williams.
All right. Where is Tara?
She's hospitalized and has been, so she won't be able to make any of the court dates.
All right. Counsel.
I had a chance to speak, and there is no dispute as to the amount owed. I'm showing 4623.50, 229.18 of cost for a total of 4852.68. We're going to be doing a consent judgment as to Miss Williams. She gave me her permission to sign, and then we'll be doing a default judgment as to Sergeant.
All right. Do you understand and agree to that?
Yes, I either have like to pay or leave by the 12th.
Correct. And it's 4852.68, right, counsel?
Correct, Judge.
And if I'm not able to get everything out by the 12th, will it be like thrown on the street or something?
Yeah, you have to get out and turn over the key, but get all your property out of there by the 12th. Otherwise, you're going to be evicted.
Okay.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. Do you understand that, Ms. Williams?
Yes.
So I'm going to sign a consent judgment versus Ms. Williams for 4852.68, writ date on the 12th, and it will be a default judgment versus Tara Sargent. And again, that writ date will be the 12th of June, and that's the amount to be paid to save it, as I previously enunciated, 4852.68. So I think that's it for you, ma'am. You're all set. I wish you well. Good luck to you, counsel. You can go in and talk to Nathan Albrecht, and I will be right here when you come out. Thank you.
Sounds good. Thank you, Judge.
All right. Gibraltar Point versus Amber Poma, 2501973. Mr. Osinski, your appearance.
Good morning, Your Honor. Donald Osinski on behalf of plaintiff.
Is Amber Poe here? Poma.
No, Your Honor.
All right, you can go ahead and proceed. This is going to be a default judgment.
Thank you, Your Honor. With the defendant failing to appear, the plaintiff would like to request a default judgment in the matter. I'm showing rent to retain as $2,670, court cost in the amount of $184.17 for a total due and owing today of $2,854.17. We'd like a pay or move out date of June 12th, 2025. There was one late fee of $100 that was reduced to $70 as well, Your Honor.
Default judgment will enter 285417. The writ date will be the 12th, and this will be by default. Default judgment will enter against Ms. Poma. Gibraltar Point versus Melissa Squires and Robert Squires, 2501974. Squires, are you here?
I have not had them check in, Your Honor.
You can go ahead and proceed on this one.
Thank you, Your Honor. Good morning, Your Honor. Donald Osinski on behalf of the plaintiff. With the defendants failing to appear, plaintiff would like to request a default judgment in the matter. I am showing rent to retain as $2,675, court cost in the amount of $223.56 for a total due and owing today of $2,898.56. We'd like a pay or move out date of June 12th, 2025. There were two late fees of $75 that were reduced to $70 as well, Your Honor.
Defendants failed to appear. Default judgment entered in favor of plaintiff against defendants. Writ date will be on the 12th of June. The amount to be paid to save it is $2,898.56. Gibraltar Point versus Matthew Wilcox, 2501999. Is Matthew Wilcox here? iPhone there, what's your name?
Bobby Bell.
All right, you got to identify yourself on these folks, please. Help us out.
I just did the text. I thought I did. I'm sorry.
That's all right. Bobby Bell is Matthew Wilcox here, Jennifer?
Your Honor, we did submit a dismissal in the matter.
Oh, okay.
We might have missed polling it. I apologize.
Dismissed. Motion to plaintiff. All right. Do I have to wait on you to meet with somebody, or did you already do it?
I am just waiting on Stan Young. Then there is Park Place v. Catlin Gambo, 2002 LT. And then Epic Property versus Ashley.
All right, let me do that. Caitlin Gambo, Park Place versus Caitlin Gambo, 2502002. Is Caitlin Gambo here? Your name, ma'am?
Yes, Your Honor.
Tell me your name.
Caitlin Gambo.
Did you listen to and understand the rights on the video?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
Intend to apply for funding?
No, sir.
Counsel, your appearance?
Good morning, Your Honor. Donald Osinski on behalf of plaintiff.
Give me the total amount owed.
The total amount owed today, inclusive of court costs, is $2,134.17. There was one late fee of $75 that I did reduce as well.
All right. Why don't you give me a breakdown, if you would?
Yes, Your Honor. So I'm showing rent to retain as $1,950. Court cost in the amount of $184.17 for a total due and owing today of $2,134.17.
Ma'am, can you pay that amount?
Sir.
I can't hear you.
No, Your Honor. I cannot.
You gonna be able to pay it by the 12th?
No, Your Honor.
Do you have another place to go?
Yeah. Yes, Your Honor.
Counsel, I'm gonna give her a couple more days. The 12th is on Thursday. I'm going to give you till the 16th. Writ date will be the 16th, ma'am. So you have to be out or pay up by then, okay?
Thank you.
You're
Your
welcome.
Honor.
And
Your
that'll be after hearing. I'll ask you to submit that judgment. Thank you.
Thank
Ma'am,
you.
best of luck to you. Thank you.
Thank you.
Epic Property versus Ashley Leday, 2502027. Ma'am, your name?
Ashley Ladee.
And Mr. Ozinski?
Good morning, Your Honor. Donald Osinski on behalf of plaintiff.
Ma'am, did you listen to and understand the rights?
I did, but I got disconnected and wasn't able to speak to him.
Ma'am, we don't put you in with the attorney right away. Judge speaks to you first.
Okay, I'm sorry. I apologize.
All right, do you wish to speak to a lawyer?
Yes, please.
I'm gonna give you that. I'm gonna adjourn it 1 week to June the 9th. At what time, Jen?
They are scheduled at 9:30.
At 9:30. Counsel, just tell me the total balance as to what is owed so she knows.
Yes, Your Honor. I am showing rent to retain as $2,810.06. Court cost in amount of $184.17 for a total due and owing today of $2,994.23. The late fee is only $50.
That's why I wanted to speak to the, however we do it. They added this month's rent onto it. So my court papers are.
Well, they have the right to do that. We're now into June now.
Right. When this happened before, I was told that the months now is not due with this one.
Who told you?
I'm sorry?
Who told you that?
When I had to do this last month, unfortunately.
You weren't in front of me, were you?
I was not, no.
Yeah, when the calendar turns to June, you owe that rent, that month of rent, and they have the right to include that.
Right, but they didn't include it on the papers that I got, is what I'm
But
saying.
they filed the papers before June 1.
Right, so.
They
okay,
didn't,
so
you weren't gonna pay. They were telling you what was owed as of that time. Do you agree that if you include June's rent, that $2,994.23 is the balance?
Yes.
Okay, all right, so we're on the same page. Can you pay that?
No, I cannot. I'm going to be able to pay the 174806 by the 12th, and then
Wait, you're cutting way out. Tell me what you were saying again.
I'm sorry. I'm going to be able to pay the 174806 by the 12th, and then I will have June's paid that week after.
All right, here's what I'm going to do. Counsel, I'm going to give you a judgment. It's going to be for $2,994.23. And the writ date's going to be June the 12th. And if she pays $1748.06 by June the 12th, writ date will be extended until June the 20th. Okay, ma'am, so I'll do that for you. I'm going to give them a total judgment amount of $2,994.23. The writ date will be June 12th. If you pay $1748.06 on or before June 12th, I'm going to extend the writ date until the 20th, at which time you have to pay the difference between the $2,994.23 and the $1748.06. Do you understand that?
Yeah.
Well, you just told me you could do that, right?
No, yeah, no, I will be able to do that. I want to make sure that like last month I was able to have more time, but I should be able to have the June by that date. There's like a if with a few $100s. That's why I unfortunately have to pay the due the fees every single month. and I've been doing
Now,
that, which is
Slow
fine.
down, slow down. I'll extend the writ date on the second one until the 24th. So I'll give you those couple extra days.
Okay.
So the judgment's going to be for 2/9/9/4/23. Writ date will be June 12th. The other orders that will say if defendant pays 1748.06, writ date is extended until June 24th of 25, in which case you'd have to pay the differential, all right?
Okay.
All right, good enough?
Yes, thank you.
All right, best of luck to you. Mr. Osinski, submit that order to me, please. Thank you.
Your Honor,
Yes, Your Honor, I'd just like to make an objection for the record.
That's okay. I know, I got it. It's all right. Won't be the first time a lawyer's objected today or by the end of the week, for sure. So that's all right. That's what I'm going to do. I've got Granite Televalley. Let's see here.
Your Honor, if I may interrupt for just a quick second. Mr. Young, am I supposed to show him the video before I put him in with the attorney? Because I didn't know he was here. I was in a breakout room.
Mr. Young?
Boardwalk.
Oh, I went through
Apartments.
the rights.
You went through the rights. Okay, then I will put
Yeah.
him in with the counsel. Thank you. I just wanted to make sure
Yes,
before I stuck
folks.
him in.
Do you have any more, Mr. Osinski?
Not at this time, Your Honor. Talking to Mr. Young will be the last one. We called all my other cases.
Okay, good enough. Sonia Regis versus Labille Pfizer, 2501822. Do I have Sonia Regis here?
Judge, I have the 10 o'clocks. I have not had the opportunity to show the video yet to the defendants.
Your Honor, I am here on Regis, Greg Barbie, appearing on behalf of Regis. I think she plans on being here.
Did you file an appearance?
My office is doing it this morning. I'm sorry, they're in the process of doing it now. I was just retained late last week.
Okay, I need to pass that case until I have a appearance, okay?
Okay, she's doing it right now.
Good enough. Ashley Rocket versus Brent Dawson, 25-01931. Where's Brent Dawson?
I don't have Mr. Dawson. I do have Miss Rocket here. She's logging in now.
This is the one where he was apparently picked up for violation of a conditional bond. And the detective called me last week when he was in custody asking when the court date was, and I told him to convey it, and I trust that we sent a notice out setting it for today at 10, correct?
We
Jen?
did. Yes, Your Honor.
When did that go out?
That went out the same day as the hearing.
Okay, Ms. Rocket, your name?
Ashley Rocket.
All right, so this is simply, let me see. This is just termination of tenancy.
Yeah.
So you allowed him to live with you and now you want him out?
Correct.
Well, he's not here. Jennifer, can you prepare a default judgment, please?
Yes, just give me 1 second to get the form up.
So that writ date will be June the 12th. We'll prepare that judgment for you. That'll be for termination. And we'll take care of that and send that out, okay?
Okay, perfect.
You're all set.
Okay, all right, thank you.
Have a good day.
You too.
Iqbal Amir, Unbreach Amir versus Daniere Marvin Delshoni and Jeanette Trix Gill, 2502004. Anybody here on that?
The plaintiff is here, but he was I just let him in, so it may be a second for him to connect.
Your name, sir?
Bobby
Amir,
Amir, go ahead.
Amir Iqbal, yes.
All right, do I have here either Daniere Delshoni or Jeanette Gill? I don't see where he paid for a second mailing.
No, Your Honor.
Reschedule. I'll make a note, defendants to be in person, and we're gonna set this for, give me your next date.
June 9th at 11.
June the 9th at 11, Mr. Iqbal, okay? If they don't show up, then I'm gonna give you a default, all right?
Sure, sir. Thank you.
Have
What
a good
date?
day. See you next week.
Thank you, sir.
Bobby Bell versus Tamisha Bell, 2502024. Mr. Bell, your name?
Bobby Bell.
Ma'am, are you Tamisha Bell?
It's Tamisha Morris, actually.
Okay, good morning to both of you.
Good morning.
So you were renting out the house to her, correct, Mr. Bell?
Not necessarily renting. She was living there and was supposed to be paying the mortgage while she was living in the house.
Ma'am, did you listen to and understand the rights on the video?
No, I did not. I didn't
Judge,
hear
I don't
anything.
think she connected to the, I can do that really quick if you'd like.
Yeah, why don't you do that? We're gonna take a 5-minute recess. We're gonna take 5 minutes. I'll be back here at about 10:25 at the latest. Stay seated, everybody.
Thank you.
Sure, Cordell. Okay, I just saw Mr. Burbank. He's in another court. He'll be back shortly. Cordell Howard is next. John West.
My detective that took the confession is gone Tuesday through Friday of this week. I can try it next week or the week after, but I can't try it this week.
Yeah, I'm sitting in the one next door, picking here, whatever, and then say, so.
Now, everybody else is ready. Everything else is ready. So once that detective gets back, we're good to go. But the defendant did confess to him, so I need him.
Yeah.
I would suggest not the 9th, because I know that there is a priority case that's on that docket already for you. The week after that, though, the trial docket after that, though.
This is the second trial docket next. That will be reset for doing.
Thank you.
Yeah.
I think I'm going to dismiss this next case, Terrence Bush. Yes, sir. I'm going to work on that right now.
Mr. LeBlanc? Mr. LeBlanc? No. Stephanie Watkins?
That should be a plea. You have had that confirmed from Ms. Carrazzo, Judge.
Walter may mobilize? Yeah. Here we go. What are we gonna do?
We don't know about that. No, it's pleading. I think we need a whole lot of judge when you have a discussion. That's an issue.
All right, Lance Dixon.
That's Mr. Burbank.
Our victim is in the wind, but we're going to find her. But I can't get the victim by this week.
Derek Jones, John Webb.
That we tried that case back like a year
Yeah, it's
ago.
familiar.
He got life. So I think these are just waiting for the appeal to. Yeah.
Because if the appeal is,
What is the status on it?
I think that we've already submitted briefs. The state has, and I think I
When
think
we
it's
review it
waiting
in a
on.
couple of months,
that's how
60 days,
I'm sure it's
review in 60 days.
will dictate what you hear.
Derek LeBlanc. John.
Oh. I say it out there, our next door, number one next door.
What about this? I mean, these are two thefts, really?
Yeah, let me see if I can do something today. See if I can, I know in the past we weren't able to work it out, but we'll see.
I thought that there was a potential.
We are gonna work it out, Tron. We just don't know it yet.
There you go then. I don't know that part.
In the wind.
Yeah.
Right. I'm working.
John Lonnie Lewis.
Judge Mr. Lewis was tried back in January, got 15 years, so I'm just listening to the case, he didn't appeal it, so there's no appeal anymore. I filed the dismissals and sent them to the police.
Okay, so those cases could be dismissed?
Yes, sir.
No, that has have to reuse the files, so this might be files some of those are used. They're not, so some files are personally. We just put it up, so things are like the 257 isn't even in policy.
Okay.
So this is probably.
Well, I really need because so I can see the name of it.
Yeah. Well, about to say, we can even run the names on it, if that's what you need,
Yeah. That's all. And the numbers.
and the numbers.
Well, the number's okay, it's just the name.
Okay, yeah, we can do that.
All right, on again, Lonnie Lewis, the state's going to send me something.
This already did.
Thank you. Gabriel Jones. John, again.
Convey the new officer to Mr. West, Judge.
Yeah, Sean, we'll talk about that.
Okay.
Over the weekend.
Don't go. Ronald Babineau. I'm sorry, Ronald LeBeau.
Okay. That is.
23 CR 164.
That one we have an offer that my client's rejected. That's gonna count 10. He said, no, I don't know if they want to change that offer.
No.
Okay.
We'll stick with that.
Took it out then.
We've got everyone ready. We would need to know as soon as possible because there is a witness from Denver that we have to fly here.
Okay. Is on this one, is he eligible for probation? There's nothing in the indictment, but
I'd have to check, Judge.
can y'all, what do you know about it, John?
I think it's, that's under, I think the reason I gave us a cap.
No, that's not what he's asking. He's asking for the jury.
There's nothing.
No.
Indictment,
I look back there and kind of catch up.
yeah, it's a state jail conviction, so unless
Not
it's been
eligible,
appealed, yeah, he's not eligible for probation.
Very.
Okay, let me look at one thing. You okay there, kid?
I think it's another one of those pretending they have a firearm.
Glenn Duncan Jr. And Judge, you met Langston?
He's here, that I was requesting a continuance on this case so he can hire me on the, he hired me on the first case.
Cases on the docket, Judge. Mr. Adams is only hired on the first one.
I've only been, just I haven't been paid a penny, not one dime on the second case, zero, nothing. So, he did bring in a payment to me yesterday for the
The
original
day before
case.
trial.
Yeah, but that other case, I haven't got one dime, zero. So,
When did I become the collections agent?
no,
I thought I was elected criminal district court judge.
no.
That's y'all's issue, not mine, you know, Mr.
So that's why I was.
We're talking about 460 days.
Judge, I have no objection to it being reset.
A year. But
The state is ready if we proceed on the first offense, but I don't have any problems with giving Mr. Adams time to take care of that.
Is it enough? Okay. Cool. Like I'm not even telling you. Like you just went through the street. Somebody's just come on. Let's have this on. No, let's find it out. If you make them monitor that, I don't get it up. I didn't know I learned on my mind. I forgot to say. Sorry about the, let's see. Oh, I'm like, oh, I'm like, it's about life. Which one are we? Right, anything?
He said, not.
Said nothing. Yes, I think that was
Hey, Jimmy.
Yes, sir. Ma'am.
I looked, I was trying to figure out why they were separated. One of his cases has him listed as a junior and one has him listed as the third. So
It's same guy. Thank you.
that's why I got separated. So.
Thank you.
You didn't ask for it, did it?
Yeah, I changed the caption, but the body of the indictment wasn't changed on 74 to 74.
Yes, sir.
No problem. Does that point, I don't know, we grab anything up there with it. If you have it.
On 1604, please.
Yeah, that's all.
Okay. You can see where we're headed on there, on this. You're gonna sit in, that, in the jury box. And we'll take care of some things later with you. Okay, I'm Marvin Parker. Todd LeBlanc. I had Mr. This is like the second or third docket. Mr. LeBlanc hasn't been around. Can we call him and find and invite him over? Then John.
I think he's back with a tablet signing some of the.
Mr. Reynolds. Anybody at all? Anybody at all?
Mr. Reynolds is visiting.
Any lawyer at all?
Mr.
Thank
Reynolds.
you. I know. I see him. It's just, it's the 100 who aren't here. I see the 3 who are here. It's the 100 who aren't here for some reason.
Mr. Reynolds is visiting with Mr. Green about a new opportunity.
Is he? Okay. Mr. Delage? Ms. Delage?
She's talking with her client back there, Your Honor. I
They're
believe you
talking.
may accept the.
Well, we wouldn't want to wait until 15 minutes after the trial docket to begin discussions on resolving a case, would we? How about you, Brent?
Sonny, yeah, I'm gonna accept just dismiss.
Okay, you've got Travis Hingston. What are we going to do on that?
I submitted a dismissal in that case, Judge.
Okay. And Mr. Wilkerson on Mitchell?
Mr. Wilkerson called in sick this morning.
See, that's creativity. See, we called in. I'm sick. I can't believe it. Okay. Tom? We got a bunch of stuff here. Yeah, 2 things, right?
First one on the docket specially set, it appears he's not taking the offer now, so.
We need to bring them out. I need to put it on the record. Must suggest the rest of the court.
Okay, what about?
My understanding on the other advance.
Dixon.
The state may have a problem with a witness and was asking for an officer in training or something.
Who's got Lance Dixon?
I do.
Okay.
What's our plan on that?
I don't, I'm gonna get to a reset judge. And
Talked to Mr. Burbank about that on Friday. The victim has a revocation in the court next door, and once she's arrested on that, we'll be able to get this trial scheduled.
Which will end in a dismissal.
Yeah, they're still playing that angle.
I mean, is that true or is it just a bunch of baloney?
To me, it is.
But I think you say that in every case, but I mean, really.
No, not really. It's quite a circus.
Well, welcome to this courtroom. It's just not the clowns and the popcorn. I'm sorry, not the popcorn. It's just a. All right, we'll figure all that out. Let's get the stuff that needs to be weeded out right now, so I know what I have left. And I guess I need to have, there's a bunch of stuff.
See how long it lasts.
So I've submitted 3 dismissals to you.
Great.
Yes, sir.
Travis Hingston in. Cross number 24 CR 1098. That case is hereby dismissed. Terrence Bush, 39980. That case, those got two cases there. Are both of them to be dismissed? On Mr. Eckert?
Sir.
On Terrence Bush, two cases? Yes, be dismissed. I've got one.
There's
Another one coming?
should be. What was the deal about signing up?
39980 and 39981. State of Texas versus Terrence Bush. Each of those cases are dismissed. 24CR1098, Travis Hingston. Dismissal is before the court, it is being signed.
I see that.
Thank you. Four cases on Lonnie Lewis. 23 CR 784, 23 CR 1274, 23 CR 250, 23 CR 251. Motions to dismiss are presented to the court of each of those. I'm signing them and those are hereby ordered.
Well. That's fine. Why is this only investigated?
Yes, I have, but.
It's all so long as you can see. You'll see what happens to the loss.
I missed the.
Yes, after the loss.
Well, I've talked to being on down, you'll have to. Yeah, we can't. Find the last one, the tablet meeting.
I trust you. I believe everything's.
Three cases on Cordell. Howard, Mr. West, Wayne. Mr. Eckert. That's to be reset,
Yes, sir, for one of the dockets in June.
sir.
One of the dockets in later June.
Reset until, I guess, 3 weeks. I have Stephanie Watkins. That's going to be disposed of. Good luck.
It's just one.
Burbank.
Best around.
Lance Dixon.
You're taking care of that, Judge. More than a reset statements for one time because
How much time?
it's normal. So
There is nothing normal here. What? How much? Boy, that didn't narrow it down at all.
I'm just kidding.
Me as well. All right, 4 weeks. Is 4 weeks good? Would that be normal for you? No. Yeah, that's what it is.
Yeah, it's just about the smell of any problem. Yeah, well, there's a lot.
Here is Lance Dixon, Derek Jones. Thank you. Lonnie Lewis is dismissed, and here are those files. On Marvin Parker. That's that it. Yeah, I think that's it. Marvin Parker. What are we doing on that? We got 4 cases.
I don't believe somebody's hired on that question. Oh, guys.
Is Marvin Parker on bond?
He's custody judge
And he's out there hiring somebody?
I've not been notified of anybody
Yeah.
besides Mr. LeBlanc representing.
Who told you something that something was being done
Just,
on the street?
no, at my office.
Judge, we do have a letter of rep from John West.
Well, could you clear that up with John? Thanks. Marvin Parker. Is Mr. Reynolds here?
Judge, he's working on a plea on that, Judge.
And Ms. Delage?
I'm right here, Judge.
Hi.
We're working on a plea.
Gregory House?
Yes, sir.
Thank you. And Mr. Wilkerson is not here. All right. Back to Namola. What are we doing on that? What's you? What's going on with you? Are you working on something?
I'm looking cases.
Good to go. You go. Yeah. Set for trial.
We got, we had an issue arise that we need to address with the court, so.
All right.
I know what the issue is, and I've told them they need to talk to you about it, that it's not changing my offer, but they do have an issue that they need to talk to the court about.
Okay, right now?
Well, just whenever the court takes a break.
In chambers.
We're gonna be right back. Thank you. Stand by.
Yes.
Hamptons versus Temuco White, 2502033.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ms. White? Ms. White, your name?
I'm here, Temuco White. I was trying to unmute.
All right, any resolution?
Yes, Your Honor, we have a consent judgment to place on the record. Rent to retain $2,698.67. There's going to be two $50 late fees for $100 total. So a subtotal of $2798.67. Court cost of $176.54 for a judgment of $2,009.25.21. Ms. White is going to pay $1,500 by June 12. The remaining $1,475.21 by June 30, and she gave me permission to sign her name to the judgment.
Do you understand and agree to those terms, Ms. White?
Yes, I do.
So she tells me that you owe $29.25.27 and that you're going to pay $1,500 of that by June the 12th. If you do, you can stay until the 30th, at which point you have to pay the remaining balance. If you miss either one of those payments, you'll be evicted. Do you understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. And do you understand that?
Yes.
And does she have your permission to sign your name to this proposed consent judgment?
Yes.
Okay. I wish you well. She'll submit it. I'll sign it. We'll send it over.
All right.
Good luck
Thank
to you,
you.
ma'am. Thank you.
Thank you.
Hamptons versus Jacqueline Terry, 2502034. Ms. Terry, your name? Ms. Terry, your name?
Jacqueline Terry.
Ms. Austin?
Your Honor, Rebecca Austin for plaintiff. We have a consent judgment to place on the record.
Okay.
Rent to retain $2,558.08. There's two $70 late fees for $140. Subtotal $2698.08. Court cost of $176.54 for a judgment of $2,008.74.62. Ms. White is going to pay $1,400 by June 13. The remaining $1,474.62 by June 30. And she gave me permission to sign her name to that judgment.
Is that true, ma'am? Ma'am?
She looks frozen. Oh, there she is.
Ma'am, do you agree to those terms? Ma'am, do you agree to those terms? Jacqueline Terry, do you agree to those terms? Hamptons versus Lorraine Murray and Gary Pritt, the third, 2502036. Names,
Rebecca.
please.
Rebecca Austin for plaintiff, Your Honor.
Murray.
And where's Mr. Pritt?
Gary Pritt.
Ms. Terry, I'm gonna come back to you. You gotta be there. All right, let's go on this one. What do we have here?
We have a consent judgment, Your Honor. Rent to retain $2,349.77. $270 late fees for $140, so it's subtotal of $2489.77. Court cost of $221.43, so a judgment of $2,711.20. Defendants are going to pay $1,000 by June 13, and then the balance of $1,711.20 by June 30, and they each gave me permission to sign their name to the judgment.
Is that true, Mr. Pritt?
Yes, sir. That is true.
Is that true, Ms. Murray?
Yes.
So do you agree that you owe $2711.20 and that that's due by June the 13th? 1,000 of that is due by then. The balance due by June the 30th. If you make both payments, you can stay. If you miss either one, you have to vacate. If you fail to vacate or pay up on either one of those dates, you will be evicted. Do you understand that, Ms. Murray?
Yes.
Mr. Pritt?
Yes.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal this. Do you understand that, sir?
Yes, sir.
Ma'am?
Yes.
Does Ms. Austin have your permission to sign your name to this proposed judgment? Mr. Pritt?
Yes, sir.
Ms. Murray?
Yes.
Okay, you're all set. Just make those payments and you're all set. Good luck. Thank you.
All right.
All right.
Thank you.
Thank you. Bye.
Where's Jacqueline Terry? Jennifer, do you see her out there?
No, Your Honor, it looks like she possibly disconnected.
She's gonna have to reconnect or come up to the courthouse. I don't know what to tell her. Hamptons versus Robin Hay, 2502042. Robin Hay, your name. You have to start your video. There you go.
How you doing? Yeah.
Name?
Robin Hay.
Any, Ms. Austin, your name?
Rebecca Austin, Your Honor, we have a consent judgment.
Okay.
Rent to retain is $2,000.30. There's $250 late fees, so a subtotal of $2,100.30. Court cost of $176.54 with a total judgment of $2,276.84. Mr. Hay is going to pay $1,100 by June 13, and then the balance of $1,176.84 by June 30. And he gave me permission to sign his name to the judgment.
Is that right, sir?
Yes.
And you agree to that you owe that money, and you understand that if you pay that amount, you can stay. You have to pay $1,100 by the 13th, and if you do, you have to pay the balance by the 30, and if you do, you can stay in the property. If you miss either one of those payments, you're going to be evicted. You understand that?
Yes, sir. Got it.
You have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal. Do you understand that, sir?
Yes.
And she has your permission to sign your name to the judgment?
Yes.
All right, I wish you well. Good luck. We'll send that over to you. Thank you.
Thank you.
I don't know what to do with Jacqueline Terry. Boardwalk versus Stan Young, 2502001. Come on up here. Give me 1 second. Do you have her number by chance, Ms. Austin?
I'll reach out, Your Honor.
Thank you. Your name?
Stan Young.
Counsel?
Good morning, Your Honor. Donald Duslinski on behalf of plaintiff.
Okay, any resolution?
No, not at this time, Your Honor. We're just going to request the trial.
Can I say something?
Trial?
Yes, can I say something?
Wait a second. You think you paid everything?
I have it here. That's all I was trying to show him to get an understanding, but he wouldn't allow me to do that. And then I was asking him, what am I paying for? He said DT, so I asked him, am I paying DT?
DTE, you mean?
Yeah, and I was trying to understand, that's why he confused me. And then I was like, well, wait a minute, let me. Go
Hang on
back.
a second. What is he in arrears on, rent or DTE bill?
Your Honor, he's in arrears for rent for May. He's claiming that he's always paid his rent in full on time. However, going back until March 1st, that hasn't happened when the DTE bill got attached to his account, and he's only paid $775 going forward. He hasn't taken into account the DTE bill or the $50 or the late fees, unfortunately. And so there's we went round circle here, unfortunately, and we're getting nowhere because there's only been payments of $775, and there hasn't, since March, there hasn't been payments that include the DTE bill and the late fees and the other fees that are on the ledger. So unfortunately, he is behind starting in March because of that.
Okay, can I say something? I never knew about the DTE bill. My DTE bill today is current to zero. So I never knew I owed you guys for DTE bill. What is the payment for the DT bill? I never knew that. And that's what I was trying to ask you.
Mr. Ozinski?
The DTE bill was from November of 2024 through December of 2024, January through February as well.
So how much is that?
And the December through January. So those amounts were totaled $133.01.
Then I can pay that. I didn't know that, but I can pay that.
133.01?
Back from March, and then going from March, we had the late fees that were added, and then the 7-day notice processing fee as well. And we have one late fee.
How much do you think he owes in total?
I'm sorry, Your Honor?
How much do you think he owes in total?
In total, Your Honor, he owes $1,688.01 in rent, plus a court cost of $184.17 for a total due and owing today of $1,872.18.
Okay.
Do you agree that you owe that amount?
No, because I have this much rent right here. Everything I paid in cash off this app, and it comes electronically to this phone, and I was trying to show him, but he was not willing to look. On my phone, he was looking at whatever he's looking at on his end. I don't know that, but I can show it to you right here.
I mean, I don't mind taking a look at it, but I'm telling you what's gonna happen. Even if I agree with you, we're gonna have to have a trial. It sounds like there's a dispute as to whether or not the money's been paid.
Okay, so I didn't know about the DTE bill, but I mean, as far as anything else about the rent, I'm normally on top of that.
Did you pay your June rent yet?
Yes,
You paid your June rent.
yes, it's right here.
Is that right? Did he pay his June rent?
No, Your Honor, May's rent didn't get paid till May 31st, and that's according to him. It's not reflected on my end of the system yet. The last payment I have that's reflective in the system currently is from 4/25.
Is that right? April 25th, is that the last payment until you, hang on,
No,
until you made a payment on May 31?
no, every month I.
Tell me what date you made your payments.
Okay, so,
Give me the day you paid in May.
okay. That would be the 5th month, am I correct?
I don't know what you mean by that. Yes, May is the 5th month.
Right,
When did you pay it?
The 31st.
Okay, well, that's what I just said. That's what he just said. What other day did you pay in May?
Oh, in May?
Yeah.
Okay, that was for June, so.
I want to know what date you made your payment in May. You said the 31st. Did you make another payment in May?
Okay. So, it's kind of, because
I just, listen,
I'm trying to comply with you guys. One second.
You didn't make another payment in May, did you?
Yes, I made.
Besides the 31st? Did you?
No, I didn't make 2 payments in that month.
Okay, so you didn't make any other payment in May other than May 31, right? That's what he just said.
Okay.
Then he said the preceding payment you made was for April. And he's saying the May 31 payment was for May, right?
Yes.
Mr. Osinski, is that right or wrong?
Yes, Your Honor.
Okay. So he's saying you paid that late.
Okay, so I owe late charges for paying that late. That's what
You also owe June payment.
I got June payment.
Which one?
June payment is right here.
Listen to what I'm asking you now. Let's not make this harder than it is.
Okay.
He just got done telling me that the May 31 payment that you made was for the month of May, which would have been due on or before May the 1st. Right, Mr. Osinski?
That's correct, Your Honor.
You didn't make any payment for June yet, did you? Sir?
I didn't. Okay. Let me just say this here.
I don't need you to say anything. I want you to answer my question.
I thought I made this payment for this month because I paid twice in 1 month.
Which month?
It would have been 8/24. One for the 30th and one for
August the 24th?
Yeah, because I wasn't here. So yes, I paid twice.
Look, I'm just setting this for trial.
Okay, that's fine.
You guys can resolve this. You can go check each other's books before then. Okay?
Yes, Your Honor. Thank you.
Give me a date for trial, Jennifer.
Judge, how far out do you want to go? 2 weeks, the 16th?
16th would be great.
Okay, 10:30.
We're going to set a trial for June the 16th at 8:30. You guys, this will be in person. You have to be in person. Now go back and run all your things and figure out, I don't want to go through this. I don't want you telling me the May 31 payments for May or June and him telling it's for me for May. You're going to have to go back to, how long you been leasing from them?
For about 5 years.
Well, you guys should be able to go out and figure out how many payments have been made over the last 5 years. Okay?
Okay.
And I will see you guys here on that date, June the 16th at 8:30. Thank you.
Okay.
I'm sorry, at 10:30, at 10:30. Yeah, at 8:30, 8:30. June 16th at 8:30, 8:30 in the morning. Hamptons versus Jacqueline Terry, 2502034. Jacqueline Terry, is she here? She's
No,
not
Your Honor,
here.
I have not had her come back in.
We better adjourn this to June 9th, defendant to be in person.
All right, thank you, Your Honor.
Defendant to be in person, give me a time.
I'm sorry, Your Honor, I was on a call. Did you need a date? A time, I
Yes.
mean, on which day?
June the 9th.
The 9th? The
Wait,
9th is 8:30.
yeah, we're gonna June it to June 9th at 8:30. Okay, 8:30.
Thank you, Your Honor.
Thank you. Have a good day.
Yeah, have a great day. Thanks.
Too. Do I have, what'd I do with Bobby Bell and Tamisha Bell?
I'm here.
Here,
What'd you guys do now? You told me you listened to and understood the rights, right?
I do.
And how much do you think is owed, Mr. Bell?
Now I got a new statement from Citizens last week. They said the mortgage is $35,028.90. Plus I got a shut off from DTE for $2,556.51, which that total is $37,585.41.
How much were you renting this house to her for, sir?
Excuse me? I didn't hear your question.
How much were you renting the house for? 3,200?
I was nothing. She's just supposed to be assuming the mortgage, taking care of the mortgage and making sure she paid the mortgage every month while she was there.
I was making no money, no profit off of it or nothing like that.
Were you two,
We used to be in a relationship. We used to live.
Slow down. Were you two in a relationship?
Yes, sir.
Yes,
And in the house is in your name, right, sir?
Yes, sir.
And somehow.
and I am on a deed.
She is not.
You were what?
She is not on the deed. She say she's on the deed, but she is not.
I am on the deed.
And either way, that doesn't still make any payments, being paid. She
You
hasn't.
haven't paid the mortgage, ma'am, for 10 months?
Oh.
So let me explain, if I can explain, please. So the house was in bankruptcy, and then the house went from bankruptcy. It was in bankruptcy for almost 2 years, and then it went from bankruptcy to a modification. From a modification to a forbearance. Once again, when it was about to come out of forbearance, then we found the buyer for the house. After we got the payoff to sell the house to the buyer, we found out we were upside down in the house. So now Bobby wants me to go back and pay what he would have gotten if we weren't upside down in the house. We never had an agreement to pay, never had a lease or anything. Yes, I've been in the house. Neither one of us couldn't afford the house. So when the house was in bankruptcy court, and then went into the modification, while the modification was going on, we honestly thought that it was going to go into foreclosure.
Hang on a second. Slow down.
It's a mess. It's a mess. Yeah.
Why did you leave? Wait a minute. Why did you leave the house, sir?
Because we just didn't work as a couple, We wasn't.
I know, but you own the house and you left the house. And you're telling me she agreed to pay the mortgage while she was living in the house?
She did agree to pay the mortgage, and she has agreed to leave the house for it's been almost 2 years. She's supposed
Did you agree to pay the mortgage, ma'am?
I did not agree to pay the mortgage,
What did you agree to pay?
What did I agree to pay? Nothing.
Yeah. Nothing? What a great country. You mean you thought he was just gonna leave the house, let you stay there for free?
Absolutely not. The house was going into
Ma'am,
foreclosure.
I want you to listen to my question. Stop.
All right.
Stop. Are you telling me, how long ago did you leave the house, Mr. Bell?
It's been over a year, probably a year.
All right, slow down. That's all I wanted to know. You're telling me you left the house, no agreement, and just you can live here until?
No, it was a verbal agreement that she would take care of the mortgage until she was able to leave that house and find her something else. We've had sales for the house a couple of times, and she won't leave the house.
Hang on a second, guys. Wait 1 second.
I am the one who got the sales for the house.
Right. The judge said to wait.
Can I please speak?
Wait.
Okay.
The judge said to wait. That means you don't say anything. Well, I can't say that this isn't something that I've seen happen before. I mean, this is what happens. People think they can commingle, live in different houses together. One owns, one doesn't own. One rents, the other doesn't rent. And now you guys got yourselves in a big pickle.
Mm-hmm.
I mean, this doesn't seem right. You just can't imagine living in a house that has a $3,500 mortgage payment for free. I mean, this would be a great country. Maybe they'll let me live in their houses in Hollywood for free. I don't know what to tell you two. Don't interrupt me. I think you both better get some lawyers in here that know what they're doing. I'm adjourning this 2 weeks. You guys get some lawyers. That's what you need to do. This is an expensive asset you're talking about. You don't want to lose everything, Mr. Bell. I don't know what the status is. I don't want to know right now. But you gotta, how much is that house worth?
It's work, they did, appraisal and they saying, like right at, 500 now. But she got it so upside down, I had to pay, I would have to pay to sell the house.
I have it upside down.
Hang on a second.
Your-
Hang on a
Your Honor,
second.
can I please say something?
Ma'am. I'm not gonna be here to referee this right now. I'm not gonna let you guys squabble across the cameras here, telling one why the other one got it upside down, or he did, or you did, or anybody else did. I'm adjourning this to June the 16th at what time, Jen? And you're gonna
10
come
a.m.
at 10 a.m. and you're gonna come back with some lawyers. And then we're gonna set it for trial. Okay? I mean, you guys are both hurting each other at this point, as far as I can tell. But I don't know all the details, but I'm sure I'm certainly not going to resolve them now. But when
Yeah,
you take-
tell him why you couldn't go to the, I had to get a restraining order on him. He was abusing me. It's a lot of stuff, a
All
lot.
right, hang on.
If you check the records, I've called the police here so many times before.
Ma'am, that's the first I've heard of it.
Yeah, because you wouldn't let me talk.
Ma'am,
Okay,
you need to get a lawyer.
yeah.
Did you charge, was he charged with anything ever?
No, because I could never catch him here. He
right.
wasn't.
Slow down.
No,
You said that you had restraining orders on him.
yeah.
Did you get PPOs, or were these?
I got a
Hang on, I didn't think I was done talking yet. Did you think
Oh, I
I was
didn't know.
talking yet?
No.
Would you please stop interrupting me?
Okay.
Did you have charges that you filed against him where he was the defendant in a domestic violence charge?
No, I
You
just
said,
got.
hang on. You said you had a restraining order. Did you go down to Detroit and get a PPO against him?
Yes,
All right, is that PPO still in effect?
no,
Does that PPO have anything at all to do with the fact that you guys got yourselves in a deep issue here with regard to the loss of this property, whether it's Mr. Bell's owned otherwise, or you own some or don't own some? Do you guys realize does that have anything at all to do with this?
no. Can I say this, Your Honor?
Why are you
Can-
bringing up issues that have nothing to do with the fact that this house is apparently underwater and he thinks that you owe him $35,000?
The reason why I'm bringing it is to establish that he's doing this to be vindictive. That's why.
Might be, and I'm gonna hear all that at trial, ma'am. I'm not foreclosing you from arguing anything. I think that this is.
Yes, he's doing it to be vindictive.
Why are you interrupting me again? Please. He might be. I'm not saying he is. I'm not saying he isn't.
He is.
All right, okay, stop. I'm adjourning this to June 16th.
Look at him. Happy that he made me cry. I'm telling you.
I'm not happy that you keep interrupting
He
me.
is.
I'm not happy that you keep interrupting me.
Your Honor, I'll just leave. I
Hey,
don't have to
slow
be
down.
here or anything. I'll just leave. I don't want to drag this out and have this man in my life anymore.
All right, slow down.
leave.
All I'm telling you is I'm encouraging both of you to get lawyers, and maybe you can actually work together so people don't.
We're not going to be able to. He's crazy. And he's sitting here pretending like he's not. And I know it may seem like that I am because I'm interrupting you, but I have been through a lot when it comes to this man in this house. I dumped my money into this house just like he did.
All right, then maybe you guys should figure something out. I'm telling you what I'm suggesting. I'm telling you both you should be here in person June the 16th. I'm telling you, you should come with some lawyers, and then we'll figure out, they can figure things out. June 16th at 10. If you don't want to, I mean, I don't know what to tell you, ma'am. I'm gonna hear you out. You guys come here with lawyers, we're gonna set a trial date, or they can resolve it. But I think you need some representation, both of you right now. If you're in danger of losing a house worth $500,000, I don't want to know how much debt you have in it, what your mortgage is or anything else. Just come here June 16th at 10. If it's not resolved that day, I'm setting it for trial. But you're going to have to prove, sir, that she agreed to pay that. If that's what it is. You got some obstacles here, both of you. I'm just telling you both, I think you'd be much better off with a lawyer on June 16th. And then I can set it for trial. You raised your hand, ma'am. Do you have anything else?
I do. I want to ask, if I can just leave and not have to come back to court. I don't.
Lady, it's a scam orders, Your Honor.
What's that?
I put all those names on the thing because she uses several names. I've been to the police, we made a report, and they know who she is and how she does, because just like she doing this crime scene now, she'll do some stuff. She spit on me, did all kind of stuff, and then call the police and act like I'm doing stuff to her.
Governor, he is lying.
All
He
right.
is lying.
Okay.
Get these eviction
Sir.
and file the report
Sir.
so they
He's
would know.
lying.
Sir.
The reason
Ma'am,
he's lying.
ma'am.
Yeah.
He's claiming that you owe him money, and he's asking me to evict you. So in answer to your question, if you choose to vacate this case, as far as I'm concerned, he didn't pay for a money judgment. This will be a moot point. He's not suing for a money judgment right now. So you can go consult with a lawyer. I'm not going to give you advice. I strongly think you should consult with a lawyer. I'll see everybody here
The
June
volume went out. I
16th.
can't
Hang on. At 10 o'clock, and that will be in person. Okay, please? In person. All right? We'll see you guys then, June the 16th at 10 o'clock in person. Thank you very much. All right, now, is that it? Do I have Pitaways versus Pitaway here?
Your Honor, I did want to let you know on 25-01822, the appearance did come in.
All right, let me get that one out. All right, Sonia Regis versus LaVille. Pfizer, 2501822. All right, everybody's name on here. Ms. Regis, your name.
Sonia Regesh.
Okay, ma'am. Mr. Barbie, you are representing,
Yes, Ms. Regish. Your Honor.
state your appearance.
Gregory M. Barbie, P71135, appearing on behalf of Sonia Regish, who is appearing via Zoom.
LaVille Pfizer, your name.
No, Pfizer.
All right. Did you apply for funding, sir?
I did, and I just had to update it yesterday because of, we're into another month now.
Did he submit that proof of application for funding to the court within 5 days, Jennifer?
I didn't submit it. I had to update it yesterday.
Did he submit that application for funding, Jen?
Judge, I'm double checking.
Judge, I didn't submit it within 5 days.
Well, I told you you had to submit it within 5 days.
I didn't hear, like, I didn't hear
I
that
tell
part.
everybody that. I tell everybody that.
Yeah, I'm sorry, I didn't hear that part, but I did apply for it.
I did. I tell everybody that. I just can't believe that I missed telling you that. I'm sorry.
No, I'm not saying that you, like, I didn't hear that. I'm sorry.
In Your Honor, if it helps any, my client filed this on her own, but she's no longer seeking the money damages. She just wants possession of the house.
Yeah. Let me check on something here. Jen, are you still there?
Yes, I'm here, Your Honor. I don't see that we received anything from at the court.
So you can tell me how much is owed, Mr. Barbie.
So rent would be $4,500, including June. There are no late fees. And then court costs would be $163.50.
So you're not seeking a money judgment?
No, we just want possession, Your Honor. We want to keep it simple. Just remove Mr. Fleischer from the house and move
Do you agree
forward.
that you owe that amount, sir?
Yes, sir.
All right, well, he's not asking for a money judgment. Right, counsel?
Correct.
I'm gonna go ahead and fill this out while I've got you here. Just give me 1 second. And it's, what's the amount of your cost? 163.57?
50 cents, Your Honor, 163.50.
So I'm gonna give him a judgment by after hearing. You may be liable for money damages after moving if additional rent is owed or there's damage to the property. No money judgment is entered at this time. Acceptance of partial payment will not prevent the court from issuing a writ. So you owe $46.63. You have to pay that. $46.65.50. $46.63.50. My apologies. $46.63.50. You have to pay that amount on or before June the 12th, okay?
Yes, sir.
If you pay that, you can stay. If you don't, you have to vacate by then. Any questions?
I appreciate, thank you.
Have a good day.
You too.
Thank you, Your Honor.
Thank you very much. Thank you. I filled out the judgment. We'll send it out.
Thank you very much.
Do I have, which one are you here on, Mr. Ingram?
Granite Televalley, we're waiting for Mr. Albrecht and appears that he is here and I have spoken to him, so we're all good on that one, if we can go on the record.
All right. Granite Televalley, jeez. Yeah, this is what happens. Which one? Granite Televalley versus who? Albrecht, okay. Granite
Albrecht.
Televalley versus Albrecht, 2501710. Everybody's name?
Brent, take over the plaintiff.
Sir, your name?
Nathan Albert.
Good morning. All right.
Good morning.
What are we doing on this one?
We're going to be doing a consent judgment, Your Honor. I've got the total rent at $3,978.90. There is no dispute as to the amount owed. I let him know that the writ date would be the 12th and that he has that amount of time to either pay or vacate. And he has given me permission to sign his behalf as well, so I can get that submitted today.
So the total amount of the judgment will be $3,978.90?
Correct, Your Honor.
And sir, do you understand you have to pay that on or before June the 12th? If you do, you can stay. If you don't, you'll be evicted.
Yes, Your Honor, I understand.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, Your Honor.
All right, I wish you well. Any questions at all? You have to pay that by the 12th or you're going to be evicted, okay?
Hey, that's the final judgment, Your Honor?
Correct.
All right.
Sir, I wish you well. Good luck to you. Thank you.
Thank you, Judge.
All right, do I have pitaways here? Let me just see something.
Judge, we do have Zeal Credit Union too. They've.
I know, we do.
Okay.
I'm gonna come back and take that one. Zeal Credit Union, come on up here, ma'am. My apologies. Zeal Credit Union versus Cindy Woods, 2404676. Mr. Kennedy, your name?
Yeah, Clarence Kennedy for the plaintiff, Your Honor.
Your name, ma'am?
Cindy Woods.
Good morning. Any resolution?
Yes, Your Honor, we reached a consent judgment in this matter and we're going to put the terms on the record.
Okay, go ahead.
Yeah, so Ms. Woods agreed to make $150 payment on June 6th and $150 monthly thereafter until the debt is paid in full. The amount due today is $2,261.54, and that will be accruing interest at 13%.
All right, do you agree that you owe 226,154?
Yes.
You understand that that's going to accrue interest going forward?
Yes.
And you understand, according to the terms of the consent judgment, you've agreed to pay 150 by June 6th and the 6th of every month thereafter until paid in full?
Yes.
And does he have your permission to sign your name to this judgment?
Yes.
And you understand, so long as you make those payments, they cannot garnish wages. They can garnish bank accounts, tax returns, but not wages. Do you understand that?
Yes.
Do you have any questions?
No.
And he has your permission to sign your name to this judgment?
Yes.
All right, counsel, you're all set. Sorry to keep you waiting so long.
worries.
Best of luck.
Thank you.
John Pittaway versus Ronald Pittaway, 2502023. Mr. Pittaway, your name?
Donald James Pittaway, the second.
Okay, I don't believe there was a second mailing paid for here, was there, Jen?
No, Your Honor.
So I have to adjourn this, sir. We're gonna adjourn it till when, Jen?
The 9th at 11 o'clock, and
So
that'll
I'll
be in
adjourn it
person for the
until then,
defendant.
until June the 9th at 11 o'clock, sir. You come back here then, okay?
Do I physically got to come in, or can I come in on Zoom?
You can come in on Zoom. I don't have a problem. As long as
Okay.
you can operate it. We'll see you here then.
Okay, thank you, sir.
Have a good day. Is that it, Jen?
You do the same.
Thank you.
That's it, Judge.
All right.
Ms. Paulette, we're all set.
Understand what you're charged with, sir? Yes, sir. Paragraph 2 goes on to allege that on March 27th, 2024, you were convicted in 2 cases in the County Court of Law 2 of Jefferson County, Texas. And this was before committing the offense alleged in paragraph 1. You were convicted of violations of protective orders in those 2 cases. Do you understand what you're charged with in paragraphs 1 and 2? Yes, sir. Which constitute a 3rd-degree felony, and you're facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. Do you understand all of that? Yes, sir. And also an agreement's been reached in your case. Similarly, as the previous case, you would be sentenced to 5 years in prison for paragraphs 1 and 2 of the indictment, which constitute a 3rd-degree felony. If I follow that agreement, you have no right of appeal. Is all of that true, sir? Yes, sir. How do you plead to this? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily and because you are guilty? Yes, sir. I'm going to show you what's marked as State's Exhibit 1. Did you sign this agreement? State's Exhibit 1. Understand it, discuss it with your attorney, or the contents true and correct? Yes, sir. State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. As before, this again states you were pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. And you're giving up all rights of appeal. If I follow this agreement here, you need to sign the bottom of it, buddy. Thank you. Are pre-sentence reports waived in each of these cases? So waived. All right. Again, I've already made findings in 701 and 1745. The court finds you have pleaded guilty and true to paragraphs 1 and 2 voluntarily, knowingly, intelligently in this indictment, which constitute the state jail felony, the third-degree felony of violating the protective order. You're waiving your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of that is true, so help you God. Yes, sir. State's Exhibit 1, part of the record for all purposes. I'm going to follow these agreements of 5 years in prison in each of these cases. And you didn't sign the bottom one. Which is counsel for defendant at the bottom. So below the line, pleaded voluntarily, guilty voluntarily, knowingly, intelligently to each of the good agreements. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 in each of these cases that finds you guilty beyond a reasonable doubt, and I now find you guilty in each of these 2 cases. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years on each of these cases. These sentences shall run concurrently. Do you understand what has happened today, sir? Yes, sir. Thank you. That is all. Here, release it. Gregory House.
Yes, Judge.
Gregory House, please. All 3 cases?
Yes, Your Honor.
Mhm. Langston,
Yes, sir.
you got Glenn Duncan.
Yes, sir.
What are you gonna do on those?
I was just asking just for one final reset on them.
How is 4 weeks gonna be enough for us on that?
Yeah, we'll make it work. We'll make it work.
Let's reset 4 weeks. Defendant can come up and get a reset. Thank you.
Thank you.
Mr. Wilkerson, did you ever show up? What happened to him?
He called
He
me.
was sick, Judge.
Okay, reset this for tomorrow so we can talk
I'll email her.
about what's going on here.
Right, sir. Mr. Powell, I need you to step in front of me, please.
Right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got?
Yes, ma'am.
Okay.
John, what do you have?
I
Got this guy.
Ms. Gay, you ready on her?
Very good.
Okay, well,
I need it darker than that. I've got something that's. Okay, you must be in front of it.
three cases are called. 24 CR 761, 882, and 1243. The state of Texas versus Gregory Leon House. That's you, sir?
Yes, sir.
And you were charged with the state jail felonies in each of these cases. Is that true, everybody?
That's correct,
Thank
Your
you.
Honor.
Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
You do your.
You were here with Mr. Lodge, your attorney and the state's attorney. In summary, and we've got to do paragraphs 1 and 2 in each case. Paragraph 1 in each of these cases respectively alleged numerically that on or about March 12th, 2024, March 17th, 2024, and March 26th, 2024 in Jefferson County, Texas, you committed separate crimes of thefts involving, it looks like, the same complainant, Mr. Ramirez. Do you understand what you're charged with, sir?
Yes, sir.
And on each of these cases, hello. We've got some prior theft convictions here, don't we?
Yes, sir.
I'm looking at 10 of them here alleged. In each of these, among other allegations, the last two allege that on June 9th, 2014, in this court, you were convicted of the offensive theft and cause number 13-1827. And on January 30th, 2023, in the criminal district court, this court, you were convicted of theft in cause number 22-40688. And that is alleged in each of these three cases in paragraph 2. Paragraphs 1 and 2, the state jail felony, which means you're facing no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with and the punishment range applicable in each of these cases? Agreements have been reached in your cases where you would be sentenced to, is it 1 year in the state jail?
Yes, sir.
Yes, sir.
Okay. 1 year, we're going to do 1 year in the state jail. Is that good for everybody?
Yes, sir.
In each case, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, I do.
Do you have any restitution here?
Yes, sir.
That's important. That's got to be part of the game.
Well,
And I don't see them, I don't see it listed in
Additionally,
761, for example.
Plea has approximately 380 days served.
That doesn't matter. The restitution is going to be a part of the judgment. And that's what the victim rights requires.
yes.
And we're going to protect victims in this court. Your restitution has to be paid back, sir. That has nothing to do with anything.
Yes, and
What is the loss in each of these cases?
in 0882, it's.
No, can you do 761 first? That's where I am.
Yes, sir.
Thank you. Or 7.
That one is $141.42 to HEB in Port Arthur.
Stand by. Are there different victims in each case?
It's all HEB, Your Honor.
Focus. How much is it?
It's $141.42.
Okay. Okay, in that case, you would be pleading guilty, sentenced to 1 year in the state jail. among other things, the judgment will reflect you were ordered to pay $141.42 to the victim, in this case, HEB Port Arthur. Is that your understanding of the plan? Yes or no?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to paragraphs 1 and 2? Guilty or not guilty? So pleading guilty voluntarily and because you are guilty.
Yes.
And true to paragraph 2, those prior convictions out of county court of out of this criminal district court and other courts, are those allegations true and correct as they are alleged, and are you pleading true and correct as voluntarily?
Yes, sir.
Oh. 882, in summary, this alleges on or about March 17th, 2024 in Jefferson County, Texas, you committed theft. And in paragraph 2, it also alleges those prior convictions in 2014 and 2023 of theft in this court. Are you pleading guilty and true respectively to paragraphs 1 and 2 in this case of the state jail felony of theft voluntarily and because it is true as it is alleged?
Yes, sir.
And you're pleading guilty to paragraph 1. Correct?
Yes, sir.
Are you doing that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
Do you understand?
And Your Honor, there's restitution of $5.35 to HEB in this.
Again, in each of these cases, you're looking no less than 6 months up to, or 180 days up to 2 years in the state jail and a fine up to $10,000. Do you understand?
Yes, sir.
Agreement's been reached. You would be pleading guilty, sentenced to 1 year in the state jail. And you're certainly going to get credit for all times you have served. Restitution in this case equals $5
and 35 cents. Yes, sir. To HEB in Port Arthur.
Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. You understand?
Yes, sir.
And finally, in 1243, this alleges in paragraph 1, on or about March 26, 2024, you committed the offense of theft. And paragraph 2 as well alleges, as the other cases, that you have 10 prior convictions of thefts, including 2 June 9th, 2014 and January 30th, 2023 convictions in this court in cause numbers 1318127 and 22-40688. Paragraphs 1 and 2 constitute a state jail felony, and as before, you understand you were looking at no less than 180 days up to 2 years in the state jail, and a fine of to $10,000 can be assessed. Do you understand?
Yes.
How do you plead in these cases? Guilty and true in each of these paragraphs?
Yes.
Are you pleading guilty and true to paragraphs 1 and 2 voluntarily?
Yes.
And because those are true.
Yes.
And again, the agreement is you would be sentenced to 1 year in the state jail to run concurrently with each other. If I of the cases, if I follow all of this, you have no right of appeal. Do you understand?
Yes. And there's restitution in this one, Your Honor, $219.13 to HEB.
21913.
Yes, Your Honor.
That's HEB 402.
Yes, sir.
Is that your understanding of the plan? You have to, that restitution is owed in that amount.
Yes.
All right. If I follow this agreement, you have no right of appeal. How do you plead to paragraphs 1 and 2, guilty or not guilty? Guilty. Are you pleading guilty? And true to paragraphs 1 and 2, voluntarily, knowingly, intelligently, because those allegations are true.
Yes.
I'll show you what's marked in every case as States Exhibit 1. Did you sign those documents voluntarily? Understand them?
Yes.
Discuss them with your attorney. Are the contents true and correct? States Exhibit 1.
Down, but he's.
I know. I'm out of juice. States Exhibit 1 is tendered into evidence and without objection is submitted, among other things. You are waiving any rights of appeal. You are pleading guilty voluntarily, knowingly, intelligently, with sufficient evidence supporting your guilty plea from States Exhibit 1 in each of these cases to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements in these state jail felonies. You are hereby sentenced to confinement in the state jail in each of these cases for a term of 1 year to run concurrently with each other. Also, restitution will be owed in 761 in the amount of $141.42 to HEB in Port Arthur. And restitution is hereby ordered in cause number 882 in the amount of $5.35 to HEB in Port Arthur and the judgment. And finally, in cause number 1243, a restitution is ordered it's frozen. What is the amount? It says another user is on it. And what's the restitution amount? That is on there. So in that case.
1243, Your Honor.
Yes. It's locked. Thread it for some reason. And this is also ordered to HEB in Port Arthur in the amount of
$219.13, Your Honor.
$219.13. Okay. Do you understand what has happened today, sir?
Yes, sir.
All right. Good luck to you. Thank you.
Thank you.
Thank you, Judge.
Yes, ma'am. Stephanie Watkins, you ready? Who's that?
Ms. Peraza, up to another court, she'll be back.
Who else do we have on please? Anybody else?
Dana Gay.
Dana Gay. Come forward. That's yours, John?
Sure.
I already got one. Here you got one. Great.
Dana Gay.
This is a probation plea with pleas of true to the enhancements, making it a habitual offender probation.
Come forward. You're Dana Gay?
Yes, sir.
24-0510.
Raise your right hand. Start walking on it. Tell the whole group and yourself you got. This is okay. Need you to come up here. Hold up your right thumb. What is it? Okay. You get up one more time. I need it darker than that. Okay. Oh, no, don't. Put it over here, please. Yeah. Okay, I'm looking at contact.
24 CR 510 is called the state of Texas versus Dana Gay. That's you.
Yes, sir.
Present with Mr. West, your attorney, and the state's attorney does the definitive waive a formal reading of the indictment and arraignment. Can we proceed in summary here?
Yes, sir.
In summary, this indictment alleges in paragraph 1 that on or about December 29th, 2023 in Jefferson County, Texas, you committed the second-degree felony of fraudulent use of identifying information. Do you understand what you're charged with here?
Yes, sir.
Paragraph 2 goes on to allege that prior to that, in 1992, you were convicted in the 252nd District Court of Jefferson County, Texas, for burglary of a habitation, a first-degree felony. After that was final, it is alleged in this indictment that, according to paragraph 3, you committed the offense of aggravated assault, family violence, a second-degree felony, and were convicted of that in 2018 in this criminal district court of Jefferson County, Texas, in 18-29448. Paragraphs 1, 2, and 3 constitute habitual felony. Do you understand? So you're looking at no less than 25 years up to 99 years imprisonment or life imprisonment. Do you understand the punishment range?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And there is no fine, there's no restitution or anything like that.
Correct, Judge.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to paragraphs 1, 2, and 3? Guilty or not guilty? Are you pleading guilty voluntarily? And because you are indeed guilty in these cases, in this case, alleging these 3 offenses, the one you're accused of now and these 2 prior convictions. And in paragraphs 2 and 3, those prior convictions that we read to you, are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily because those allegations are all true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true. So help you God. Is that true? State's Exhibit 1, part of the record. For all purposes, pre-sentence report is waived.
Please, Your
If nothing further, I'm going to find, ma'am, that you are pleading guilty and true to paragraphs 1, 2, and 3 respectively of the allegations in this indictment voluntarily, knowing or intelligently. This constitutes a state jail, a second-degree felony, though enhanced to habitual felon status. You are facing no less than 25 up to life imprisonment, 25 years up to life imprisonment. In this case, there is sufficient evidence supporting the guilty plea and pleas of proof from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Be careful.
Yes, sir.
If your probation is revoked, you can then be found guilty and sentenced up to life imprisonment. Do you understand?
Yes, sir.
All right. Please see the probation officer. You're going to do well?
Yes.
Yes, sir. But it's not.
All right. Just don't talk about it. Do it.
I understand.
Thank you. Any other pleas off the trial docket?
It's Stephanie Watkins, but that's,
What's Lori?
welcome. She'll be right back.
Lori's in drug court and she's coming back.
Okay. So here we go. On this. Stephen Adams is going to be one, of course. Everybody understand? That's Mr. Burbank.
Judge.
Yeah.
He wants to come out and address the issue.
Who does?
Mr. Adams.
To me?
Yes, Your Honor.
What am I going to do?
Justice issues?
Okay, he's set number one nonetheless.
Yes, sir.
Stephanie Watkins, we're gonna do that plea. Let's see. John West
Yes, sir.
on
He's number one over there, Judge.
Gabriel Jones and Ronald LeBeau, those aren't being moved?
No, try back.
Okay, then Marvin Parker will be number two. Everybody?
You're
That's a titled loss case.
Judge.
I was part of that.
What's wrong?
Letter rep.
Yeah, I don't know why my name wasn't on that one, so
Okay, then you're number two there.
okay, but well, I'll be number two, but I will be next door as well, but I'll be
Look,
around.
here's the deal is I don't have anybody else
Oh.
on here because
Oh.
Lori's gonna be pleading the rest of your cases.
Well, if I don't go next door, I'll take one of these over here.
Okay, let's just throw one in. Is it Ronald LeBeau?
Let's do that one.
All right, he'll be set for trial. Then if not, Gabriel Jones and Marvin Parker. Those round out the field. Okay, so let me get this over to you.
Derek was long.
You want to bring Mr. Adams out?
Yeah, yes. Come on out. What's that all about? I mean, why? I don't do this. That's for y'all to deal. I deal with trials and the rules of evidence, things like that. Stephanie Watkins is going to be. I think Lynn.
Yeah.
Duncan.
Here, give me.
Glenn, here. Duncan's.
That's right. Good for Mark.
Here's Terrence Bush. James. Gabriel Jones, these are all John West. Lyle. Second. Others. That was Kingston,
That was dismissed.
Michael Mitchell, and I've got a Nestor Roque with Marvin Lewis. I don't know what that's here for.
We may have pulled the wrong file, Judge.
Marvin's not here this week.
Okay,
Yeah, I think we pulled the wrong file.
back to the case we specially said, Stephen Adams. What is this?
If we could have him sworn in, Judge.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer.
If I may, please, the court.
Go ahead.
Mr. Adams,
And it's Mr. Burbank is here representing you and the state's attorney. Go ahead. Mr. Burbank.
Adams, we have now been picked number one for trial. You understand that?
Yes, sir. I'm not ready for trial.
Hold on, let me go through it and then you can. And you understand that you're currently under indictment for aggravated kidnapping and aggravated robbery, correct?
Yes, sir.
And what I want to get on the record is the plea offer that you've rejected, okay? After much negotiation and going back and forth with you and the state has agreed to settle this case for a lesser included aggravated assault. You understand that? That yes?
I understand this, sir.
And that they would dismiss the aggravating kidnapping, aggravated robbery. Do you understand that? Good. And that also that we would go unagreed to the judge with a cap of 15 years, which means that the judge would have the full range of punishment. Could be probation, could be 2 years up to 15 years. You understand that?
Yes, sir.
You understand that by rejecting this, you are looking at first degree felonies? You understand that, right?
Yes, sir.
Okay. And that after much thought and going back and forth, do you want to accept or reject that offer?
Not accepting it.
Okay, all right. Is your decision based, is freely and voluntarily done?
Yes, sir.
And that no one's made any threats or promises against you, correct?
Yes, sir.
Okay. I have nothing further, Judge.
All right. Anything else? I'm not ready for trial. I wanted to move forward as pro se. I wanted motions that I filed ruled on before trial, so I have a fair trial. And there's other motions that I wanted to file prior to trial. I never got to file. And I'm just not ready yet. So I got the motions right here for continuance and to move forward as pro se. And that's what I would like to do. I'm aware of the risk and everything. What do you need a delay for? So I can get some motions filed.
So what? What did the motions say that need a delay?
The motion say that I wanted to file?
Yeah. What are you asking for?
One of them I wanted to file for recusal because there's bias in this courtroom. I don't trust I'm not gonna have a fair trial at all. And the other one, I want to challenge the grand jury proceedings to make sure due process was followed.
Well, what's your complaint about the grand jury?
I don't think due process was followed. Like this.
For what reason?
That's a common thing in this county. It's very common. I read case law and everything where people's had their grand jury stuff pushed through and there was steps skipped and everything and case has been dismissed. And I would just
What
rather.
case are you citing?
There was one with Hartman where the guy was falsely accused of interrupting the courtroom or whatever. And because the guy named Alfred wasn't sworn into the district attorney's office or whatever, they dismissed his case. So, like I got them all wrote down and everything. There's probably two of them.
I'm familiar with it, but you're wrong on the facts. But what else do you have? What else?
I got the motion right here. I'm not happy with how my attorney's been doing stuff for me. Like,
okay. You want to represent yourself? Okay, you can do that.
I want my pre-trial motion.
Do you understand all the consequences that are part of representing yourself? You have to know the rules of evidence. You have to know the procedure. You're going to be, and if you keep interrupting me, I'll hold you in contempt. Only one of us can speak at a time. This lady next to me has to put everything down. And if two people are speaking over each other, she can't do it.
Yes,
I'm not going to be the one in trouble you want. All right. Seems like you want to control proceedings, and that's not the way it works. But you can represent yourself. This case is over 2 years old. How long have you been thinking about representing yourself?
Since John West wasn't doing anything for me at all.
How long is, I'm asking time.
I wanted to do it April 21st, but y'all convinced me to take an attorney. And I didn't get to do anything I wanted to.
No, you can do anything you want, sir. The fact that Tom Burbank, an experienced attorney, is helping you is to help you, not to dictate anything. It's your life. You get to make the call. If you want to represent yourself, then you're entitled to do that. But in 20 years here, a defendant has never been successful, but that's your choice.
Then why did he tell me that I couldn't have any of my motions that I filed before he was appointed to be ruled on?
Well, if I could read his mind, I guess I would know, but how would I know what's on his mind on those? I don't know why he would say that. That's why you were supposed to work. Why didn't you ask him that?
I did.
But what did he say? I'm not going to answer you?
He said I'm going to get ruled on.
Sir?
Oh, like, I got certain motions that I filed that I wanted ruled on.
Okay, what?
The motion for dismiss, I wanted ruled on.
It's denied. I've read that. It is denied. It doesn't have a legal basis. What's next?
And then I want to ask why I filed a habeas corpus and was never brought to court for the bond reduction. My bond was changed from 400,000 to no bond without me being present in the courtroom without my knowledge.
All right, that it won't hold up this trial. A fact of a bond. We're moving forward. You're set for trial today. What next?
That ruled on my speedy trial.
It's denied. What's next?
My speedy trial motion is.
It's denied. You're getting a speedy trial. Here we are.
I filed it over a year ago.
It's being granted today. We're moving forward.
All right.
We're going to try the case today. This is what you want. This is your time, and make it wisely.
Trial in this courtroom, but
we need to go forward, and that's fine.
Thank you. Okay. Yeah, well, anything else?
No, Your Honor, I will stay on if he needs any assistance.
Neil, stand by. You want to represent yourself. All right. You understand and appreciate how these procedures work, the rules of evidence you're going to be held to. And if you don't have adequate legal counsel, like Mr. Burbank is more than adequate, a very competent man, then you understand you're a layman and you're going to be starting with about a 3 touchdown lead for the defense, for the prosecution, because you don't know these rules. And it's just like in a ball game, they have to be followed, or else you are going to be or not going to be on the same level. And that's what competent lawyers do, is make sure that your rights and the laws are followed, the rights are given to you and allowed, and that both sides receive a fair trial. When you're not capable of knowing that, I've been doing this for 40 some odd years in prosecuting, in defense work, judge, and defendants never come out ahead in that regard. Do you understand? Knowing all, as long as you know that, you're grown up. You can make your choice, but it's a foolish choice to make if you don't want him to handle the case. What I'm going to do, right? You don't want it.
I just want to make sure my rights are reserved. So.
You've made your decision voluntarily, knowingly, intelligently, and that's what you insist on.
Your Honor, I have all my trial notebooks. I'll bring that so that he may have. I'll have the law books that I use so that he has everything provided to him, and will be here if he has any questions.
All right. He'll be standby. He won't be representing you. He'll be standby. If you need to get some advice from him, he'll be close by. You ask for that, and I will decide how much time, but we're not going to delay the case. We're not going to delay on you going and talking to him over and over and over again. You want to represent yourself. That's the way to do it, or else it would take months to try cases. If you went and asked him every question on every question asked and every issue, but he'll be standing by. The court will allow you if it's proper, and that is the way it is done.
Can I say something, please?
Yes.
So I think 3 weeks he's been appointed to me. I mean, that's not a whole lot of time to even really officially get stuff ready at all. Like for over 2 years, I had no representation whatsoever. Nobody helping me, no nothing. So I mean, that's how I'm saying this is not fair.
Why is that, do you think?
3 weeks.
No. How long have you been in custody?
I've been in custody for 27 months now.
27 months.
Judge, we had this discussion, to be fair to Mr. Adams, we had this discussion. He claimed that no one had come to contact him. None of his lawyers had gone over any of the discovery with him. And then Mr. Burbank got appointed. And then
Well, John West when was John West appointed? I go back on July 7th. Where's Mr. West?
Right.
John?
Yes.
You were representing him?
Yes.
Back 2 years ago. Did you just disregard everything?
No, I talked to him several times back then. He didn't want to do anything. He didn't want the offer, and I was like, "Yeah, it was set for trial docket."
Okay, y'all, when you set it for the trial docket, were you prepared to try the case?
I was prepared back then until he wanted a different attorney, and that's when I got off. And actually, I got off because we found out eventually that I represent the co-defendant on this too.
That's correct, Judge.
And so at that point, I had to get off of it. That's why.
When was that?
I don't remember when that was.
Well, help me out.
We how long you been off of?
I'm back. So it's
Probably before that time
there was somebody else.
Well, Miss Minaldi was his attorney for a while.
Whenever I got off, whoever took over after me, I'm not sure.
But for 2 years you were representing.
It was bad. I didn't hear you.
Oh, wait outside. Yeah. Until down to I don't make one. Wait outside. Let's go. Follow.
What happened? What was that?
I've been waiting. Everybody important. And was that
That they some.
Yes, sir.
John West talked to me twice here at the courtroom, only offered me the 15 years. He only came in one time in the jail. He brought no case file, no that type of nothing. He ain't shown me anything. I don't know. You might be confused with somebody else or something, but my only reason why he came and see me is because my dad called him several times. He came to see me for the first time in the jail ever, January 5th, 2024.
How many times would you say you've seen it?
To be honest with you, I wouldn't even.
Give me a, come on, you've got, but I represented people and every time I went to talk to them, I noted it, but how many times did you say you started them in 2 years?
Several times, because it was here at the courthouse.
10 times?
Less than 10 times. I wouldn't say 10 times. No, I wouldn't say that. I'd say probably 5, 6.
How much time would you say collectively? Is it normal over that period of time that you discuss things?
My clients, yes, sir. That's about normal. I mean, I don't see them all like every week. I don't go to see every single client I have because I have 200, I see 217.
I understand.
But yeah.
Everybody is important. They has to be prepared.
I didn't see anything against me until Mr. Burbank was appointed to me.
When did that happen?
I still have.
And when was he appointed to represent you, sir?
Mr. Burbank,
Yes,
he
sir.
came and see me, April of April, a month ago. Only seen him 3 times. I haven't even seen Discovery in full yet. Like, I've seen the police reports and heard of bits and pieces.
What discovery is it that you, Mr. West, what have y'all done? Come on, so he knows something about.
I've actually, Your Honor, I've given him police reports, so he knows exactly.
Is that
what
true?
Everybody is saying.
Okay, why aren't you telling me that nobody's doing anything? They're providing you the discovery. Don't misinform the court.
I'm not misinforming you. I said he's helped me. He's been a big help compared to what the guy have done and everybody else has done. Like,
Okay, what is it that you need that you don't have
I
already?
see everything. I want to see Discovery in full.
Well, what is it what do you mean everything? What is it
The
that,
only thing that he probably hasn't seen, Judge, is the interrogation of the co-defendants. But we went over it. I've gone over telephone calls that Mr. Adams has made that are probably not exculpatory.
Mr. Laird, is that the discovery essentially what Mr. Burbank is talking about?
Yes, sir. There's some.
He's provided it to y'all and he's provided it to you. There's not tons of stuff here, apparently. So
Last week we provided him with the jail call that we discovered. We go through his jail calls. So
what else is there that he hasn't received? Anything?
Nothing.
Nothing.
The only thing he hasn't seen, Judge, is
Why would you say that you don't have anything when the lawyers, this prosecutor and your defense attorney now say they provide you everything they have?
No, that was everything. Nobody-
Okay, that's it.
Everything. No,
Okay,
not lying to nobody. I'm just trying to make sure that I get a fair trial.
okay. So you got the information according to them. I don't know what it is, but they say it is. All right,
we have close coming at 12:30.
all right.
I'll get you close.
You're up first.
We here with you.
I'll speak to you for a minute. I'm very-
Okay.
Okay, here. Thank you. Here's this. I have Desmond Harper. Langston.
I'm here, Judge.
Desmond Harper. What are we doing? One case?
I'm working, Judge, I'm working. That's a relatively new one. I just, to an announcement just 4 weeks, but I got 2 pleas out there.
The announcement in 4 weeks?
Yeah, and the next 2 are pleas.
Anthony Patton.
I sent that to you,
I need Anthony Patton out, please.
and I sent the other one to you too.
Thank you. On Patrick Smith.
That
Or
plea. Now, the other case, can I?
Christopher Watson, right, was the,
Yeah, but that's the, Sonny, can you come up with me on that one? Yeah. Just can you hit your button?
what's, 6-3 is called. You are Anthony Patton.
Yes, sir.
Present. Mr. Adams, your attorney and the state attorney does. The defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about May 11th, 2022 in Jefferson County, Texas, you committed state jail felony of illegal possession of methamphetamine, controlled substance. Do you understand what you're charged with?
Yes.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached here that you would be pleading guilty, sentenced to 180 days in the state jail. You'll be given credit for all time served. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yeah.
I'm going to show you what's marked here, State's Exhibit 1. Did you sign that document
Yes, he did.
voluntarily, understand it,
Yes.
discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tender, without objection,
Yes, sir.
admitted. This state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, the indictment's been read here, you've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is late.
Yes, sir.
I'm going to follow this hearing. If nothing further, you pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. To find you guilty beyond a reasonable doubt, I now find you guilty beyond a reasonable doubt. You are hereby sentenced in accordance with this agreement to confinement in a state jail for 180 days. How much time do you have? Do you know how much time credit you have?
I've been in Jefferson County on this since October, but my time's been running since October.
He's got
You may be out pretty quick.
He's got another case.
Right.
Anything else? That is all. Thank you, sir.
Good luck, man.
Next, Patrick Smith.
He's done.
Mrs. Smith. What? No, you're not. He hired you back.
What do we do with Patrick Smith?
He needs to be, he's done. He just got.
Yeah, he just needs to, you know, right?
He's been doing that all weekend long. He's gonna flip flop and back. Patrick Smith and one. Official.
Mr. Smith, please see that lady real quick, and then we'll do this plea. Thank you.
Mr. Smith, right, please raise your right hand and swear or affirm to tell the truth of the truth that you got. Okay, please think of your right thumbprint. Right thumb? Yes, sir. Okay, place it flat right there. Okay, you get up one more time. Same time.
These five.
Yes.
Cause number 5CR208, the state of Texas versus Patrick Smith. That's you, sir? With Mr. Adams, your attorney, correct? All right. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed to summary? Yes.
Oh, yes.
In summary, paragraph 1 alleges on or about May 15th, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWIs, operating motor vehicles in public places while intoxicated. In 91, out of the County Court of Law of Walker County, Texas, you were convicted of DWI. 91, also the same County Court of Law in Walker County, Texas, convicted. 2001, County Court of Law of Walker County, and March 11th, 2020. Another conviction of a DWI, 4 DWIs. Paragraphs 1 and 2 constitute a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand? An agreement's been reached where you would be sentenced to 7 years in prison, given credit for all time served. Is that your understanding of the plan? Yes. If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to paragraphs 1 and 2, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? And paragraph 2, which of those 4 prior convictions of DWIs out of Walker County, are those all true and correct as they are alleged? And are you pleading true and correct to that voluntarily because it is true? I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tenders and debts?
No, sir.
Without objection admitted. Among other things, the states you are mentally competent to do this. You were entering your pleas of guilty and pleas of true voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination, totally satisfied with the representation provided by your lawyer. All pleas shall have been done. State's Exhibit 1, part of the record without objection. Pre-sentence report is waived.
Oh, yes, sir.
I'm going to follow this agreement and find, sir, you were pleading guilty in paragraph 1 to DWI and driving while intoxicated, operating a motor vehicle in a public place while intoxicated, and pleading true to paragraph 2, which alleges those prior 4 DWI convictions out of Walker County. You were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting this to find you guilty beyond a reasonable doubt from State's Exhibit 1. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony in paragraphs 1 and 2. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. Do you understand what has happened today, sir? Good luck to you, sir. Thank you. Here, thanks.
Yes, sir.
Okay, Christopher Watson, please. What are we gonna do on Mr. Watson here?
He had signed up last time we were here, but,
What was the date?
we came forth on Watson last 3/31/25.
Never come today on Watson.
Did you have something today?
Yeah.
Yeah, I had something today, which I think it was something that we had signed previously. So I think.
That was for the 18-month state jail. That's what we signed up last time when we were here.
I need him to swear in front of me if he's gonna play.
Are you gonna be pleading guilty today, sir? And this is 100, no, it's not 18 months.
Yeah.
180 days.
It shows 180 days, I think.
That's just 6 months.
What is?
Whatever it was they signed up for last time is what I
How
signed
much
today.
time does he have credit?
Yeah.
He's gotta have that kind of credit.
He got
He's
more-
ready to go.
He can get out of jail today.
He won't get out today, thank you, but get out in a few business days.
How much time does he have credit for? Do you know?
2 years.
2 years.
2 years.
He got,
He's getting closer.
last time we checked, I think it was approximately 85 days, something like that. But he has more than enough time on 180 days to get done.
6 days.
Yeah, 586 days. Is that right, sir?
I don't know.
But I mean, that sounds about right.
It's a long time.
It's a long time. I mean,
Hey, I'm ready. to be-
are you, okay, this says you're gonna be pleading guilty, sentenced to 180 days, which means you'd be getting out. Is that what you're gonna do? Is that your plan?
No, you told me, you said that I had to be guilty.
Well, you're gonna be, you have to be found guilty. You don't have to plead guilty. You can plead no contest if you want.
I already pled no contest.
No, that's not the way I do things here. I've done this for 19 years. If you plead no contest,
Well,
that's
but
fine,
if I-
but you have to, hold on.
Yeah.
Sometimes people plead no.
Year mark. Will you release? Will you let me out of jail?
You get credit. I can't do that. I can't do that, but you're credited. There's no reason for you to be staying in jail in
Yeah, can I
another
go?
moment.
Can I go? Because you offered me time served last time I
So
was
once
here.
again, sir, I can't do that. The people make the deal and then I approve it. Then I sentence you, then it goes through the processing. And if you've completed your time, you leave. I don't keep you in.
No, he's asking if his case is still pending at 2 years, what happens to him?
Well, it's a state jail felony. If you don't take the deal, we gotta set it for trial and it'll be put on the trial docket. But my trial docket today was 3 pages long. It just gets set with everything else. I can only try one at a time. I've tried 600 jury trials. I can only try one at a time. You don't have to plead guilty. You can plead no contest.
No, you told me that I was guilty and that I had to
You
be.
have to be found guilty and no contest has to be supported by independent proof. And then I make a finding of guilt. Yeah.
Well, what do you suppose now? What are you changing to?
Anything else you want to say? I'm not changing anything, sir. Do you want to plead or not today?
This is communicating. We're communicating.
All right, it's set for trial.
Today.
It's set for trial.
And,
That's all. That's all.
When people come.
We're set for trial. It's set for trial. If you're not going to plead guilty, it's not a debate and it's not a time to grandstand, sir.
This is your fault.
Golly.
I told you.
It's only another 10th time this is falling apart.
It's a political thing or something. All right, who's next? This set for trial.
Yes.
Keith DeJean, come on up. 23-313. Weird.
He's got 2 cases.
I didn't understand that. I still didn't understand that one. That's okay. Some people, I guess, love to be in the jail. But I don't understand. It's like whatever it takes for me to stay in jail, that's what I'll do, which is odd. All I can do is now set it for trial.
I don't understand it. I don't understand.
Thank you.
2 files.
I got 2 files, 2 motions to revoke probation.
Yes.
Is it one deal?
Yes.
One.
It's
I'm working.
one deal.
What part, sir? Are you Keith Patrick DeJean or DeJean? We call 23 CR 313 and 314. There are 2 motions to revoke probation. You will hear that your attorney, Mr. Dusler, does the defendant waive formal readings of these motions. Can we proceed in summary?
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, we'll take these together if we can. In summary, these motions similarly allege that on July 25th, 2023, you were sentenced to 2 years in the state jail, probated for 5 years in this court for thefts of property. Is that true?
Yes, sir. Whatever counts you on.
Okay. Okay. Number 1, in each case states you failed to report to your scheduled administrative hearing on October 10th, 2023 in violation of your probation order. Is that true?
Yes, sir.
And number 2 states you failed to never become intoxicated or being under the influence of any intoxicating substance, and that on October 19th, 2023, you tested positive for methamphetamine, which was in your system. Is that true?
Yes, sir.
Are you pleading true to allegations 1 and 2 of these motions to revoke probation, which are identical, voluntarily, knowingly, intelligently, and because they are true?
Sir.
You understand by a knowing and voluntary plea of true to 1 or more violations of probation, that's enough to grant these motions to revoke probation beyond a reasonable doubt or by a preponderance of the evidence or greater. Probation now be revoked. You can be sentenced no less than 180 days up to 2 years in the state jail. Knowing that, you insist on pleading true. I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. In each case, agreements have been reached where your probation would be revoked based upon your voluntarily, knowingly made pleas of true. And you would be sentenced to 1 year in the state jail. Is that your understanding? If I follow these agreements, you have no right of appeal of your case, and then you would be, this would run concurrently. This says restitution paid in court. What does that mean?
We paid in full.
Oh, that's been done. Okay.
So all in favor.
If I follow these agreements, sir, you have no right of appeal. I tend to do this, okay?
Yes, sir.
I'm gonna show you what's marked as States Exhibit 1. Did you sign that document voluntarily in each case? Understand it, discuss it with your attorney or the contents attorney? Right. States Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states that you understand fully that you are giving up all rights of appeal. If I follow these agreements, I intend to do that. If nothing further, I'm going to find that in each of these cases, you have pleaded true to allegations 1 and 2 voluntarily, knowingly, intelligently in each of these motions to revoke probation. That is enough to grant these motions to revoke probation beyond by a preponderance of the evidence or greater. Thus, these motions are hereby granted and your probation is hereby revoked in each of these cases. I am following these agreements and you are hereby sentenced to confinement in the state jail for 1 year in each of these cases to run concurrently. Anything else?
No, sir.
Good luck, sir. Thank you. Okay.
Thank you, Judge.
Yes, thank you. Edwin Dixon.
What do you have on right now? The Eviction.
Let me sit down and see me first. Mr. Dixon.
Did you see the slide right here?
Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
You got your right number, right number. Yeah. Okay, look at that. Okay, one more time. Same one, same time. Thank you. Okay, you don't stand trying to touch.
25 CR 67 is called Texas versus Engaged Dixon. You're Mr. Dixon.
Yes.
Present with Mr. Dusler, your attorney and the state's attorney. Thus, the defendant waive a formal reading of the indictment and the arraignment here. And can we proceed in summary?
Yes, sir.
I don't see.
No, it's coming, Judge.
In summary, this indictment alleges that on or about November 12, 2024 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you're charged with?
Yes.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fine $500. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will.
Yes.
And because you are guilty.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily?
Yes.
Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes.
State's Exhibit 1 tendered without objection.
No objection.
Admitted. This state, sir, you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights through jury trial. Rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation that provided by your lawyer, all true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report.
Yeah, there is.
I'm going to follow this agreement. I'm making those findings that are represented in State's Exhibit 1. You're mentally competent to enter your plea. It's freely and voluntarily made. There's enough evidence to find you guilty here, but I'm going to defer any finding of guilt and place you in deferred or unadjudicated at probation for 10 years. You do well, it will be shortened to 1/3 of that.
Yes.
There will be terms and conditions of probation, which include
If I may, Judge.
$500 fine. I see restitution is in this order and it's not in the agreement. That's what y'all want, I presume. It's restitution and.
Required, Judge.
Is that right? $5,000?
In light of the amount of the restitution, Judge, I'd like to zero out the fine so that we can focus on the restitution.
The court is going to negate the fine. You must pay $5,000 in restitution to the complainant in this case.
Yes.
The victim in this case, who's listed in the indictment. I'll need to say it out loud, the name, but everybody agree that's the plan? I guess state's in agreement with you too.
Yes, Judge.
Okay. It is done. It's hereby ordered $5,000 for the complainant in this case. Anything else?
No.
Please see the probation officer. Thank you.
Marcus.
Marcus Jackson.
This is gonna go on trial on him. Yes.
In 25 CR 407, you are Marcus Jackson, sir? Is that correct? You're Marcus Jackson? Okay, Don Dusler is your attorney?
Yes.
And you were charged here with third-degree felony of failing to comply with sex offender registration requirements. This carries with it up to 10 years in prison. What are we going to do on this?
He's asking to be set on trial
What's the offer?
3 years to TBC.
Okay. And you don't want that deal? All right, I wouldn't want to go to prison either. But you talked to him and you want to go to trial?
Yes.
Okay. Do you understand you can be sentenced up to 10 years
Yes.
if convicted?
I live at my residence.
I'm sorry, what did he say?
He lives at his residence.
Say I don't live at my residence. I do. I came in the leadership for the same case and they threw it out.
Well, I don't understand. They took it out. I don't understand what that means. You're gonna have to do this. Okay.
Same
He
case.
did have a previous failure to register that we did dismiss, Your Honor, but it's different than this case.
Oh, it's a different event?
Yes, Your Honor.
Okay. All right. Okay, then it's your call. We'll set that for trial.
He's asking that I be replaced
Why?
at the court as quickly as possible.
Well, why can't you try it quickly? It would be a real simple case to try, I think.
Got a lot of cases.
I know you do. We all do, don't we? What do you want to do? Quick as possible, get to trial?
Yes.
So then, the next person on the trial docket will be appointed to represent you. Then I find good cause, to replace Mr. Dusler, and we'll set this for trial. Next is Brian Manuel.
And you can go up to a round manual.
Are we gonna plead anything else or?
And yes. I have a round manual going on the trial. I gotta have another plea. And then another one, a mental stone.
Brian Manuel, that's you, sir?
Yes, sir.
25 CR 413, you're charged with injury to an elderly person. That's a third degree felony in the indictment, but because it's alleged you have an unlawful possession of a firearm by a felon conviction in 2016 in this court, then it's bumped up to a second degree felony. You were looking up to 20 years in prison. Do you understand? And found guilty.
Yes, sir.
All right, what are we going to do?
He's requesting the trial and he'd like to replace me so he can get.
Is that what you want?
Possible.
Is that what you want?
Okay, you said you plead not guilty when you sit for trial.
Yes, sir.
And you want it to go as quickly as possible.
Yes,
That's
sir.
why you were asking court to replace.
Yes, sir.
Okay, you want this set for trial?
Yes, sir.
Okay, it's going to be set for trial. That's your decision, and we're going to stand by that. It'll go to trial quicker, I guess. Mr. Dusler can continue to represent you. The next person on the trial docket wheel could be appointed to represent you. Is that what you want?
Yes, sir.
Okay, then I find good cause to replace Mr. Dusler. It will be set for trial, and that's the only option. Y'all be ready for trial. No deals. Thank you. That is all. Next is Joseph Thibodeau.
Yes, sir, that's pleaded.
Mr. Thibodeau,
That's two cases.
I only have one.
There's one that was criminal docket. There's a second case that was added. She should have both. We signed up both of them.
What are we going to do in Randall Manuel's case?
He has a medical report from Dr. Fafon, declaring him incompetent.
Okay.
So I don't think you just need to make those findings and there's
Mr. Thibodeau. Please raise your right hand. You swear or affirm to tell the truth and the truth and nothing but the truth of God.
Yes, sir.
Ink up your right number. Place it flat right there. Ink it up one more time, please. And press it right there.
All right, we next call Joseph L. Thibodeau III. That's you.
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
Yes, sir.
In each of these cases, they similarly allege that on July 15th, 2024 in Jefferson County, Texas, you committed the state jail felonies of burglary of a vehicle in each case. And paragraph 2 goes on to allege that you have 2 or more prior burglaries of vehicles. States exhibits, paragraphs 1 and 2 constitute a state jail felony, which means in each of these cases, you were looking at no less than 180 days up to 2 years in the state jail and a fine up to $10,000. You understand what you're charged with and the punishment range available.
Yes, sir.
Agreements have been reached where you will be pleading guilty in each of these cases, sentenced to 18 months in state jail to run concurrently on each case. Is that your understanding?
Yes, sir.
If I follow these agreements, so you have no right of appeal of your cases, do you understand?
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your free will and because you are guilty.
Yes, sir.
And paragraphs 2 in each case, which allege those prior convictions and burglaries of vehicles, are those all true and correct as they are alleged? And are you pleading true and correct to those voluntarily and because it is true?
Yes, sir.
I'm going to show you what's marked in each of these cases, what's referred to as State's Exhibit 1. Did you sign those documents voluntarily?
Yes, sir.
And did you understand, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into
No
evidence
objection.
without objection and submitted. Among other things, this states you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments and the you've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial, the rights to appearance, confrontation, cross-examination of witnesses, totally satisfied with the representations provided by your lawyer, all true. State's Exhibit 1 in each case made a part of the record. Pre-sentence reports away.
Yes, sir.
I'm going to
follow these agreements and find you pleading guilty voluntarily in each case. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. You're giving up your rights to jury trial, rights to appearance, confrontation, cross-examination of witnesses, totally satisfied with the representations provided by your lawyer. State's Exhibit 1 is admitted. That's enough to support your guilty plea. In each of these cases, from paragraphs 1 and 2, a state jail felony and burglary of a vehicle to find you guilty beyond a reasonable doubt. I so find you guilty in each case. I'm following these agreements. You're hereby sentenced to confinement in the state jail for 18 months in each of these cases. Imprisonment in state jail run concurrently. You understand what has happened today? So, yeah, good luck to you. So, thank you.
Don't think we need to bring.
Did you have any other?
No, sir. All we have is just this report from the profile on Randall Manuel.
On Randall Manuel in 25 CR 239, the court had ordered an evaluation of competency for the defendant, in this case, Dr. Edgar Kahn, licensed psychiatrist, or ordered to evaluate the defendant. We've received a report dated May 22nd, 2025, and it will be made a part of the record for all purposes as court's exhibit number 1. Any objection?
No objection.
No, sir. And it is made a part of the record in this case. The evaluation by Dr. Edgar Kahn states the defendant is incompetent to stand trial. The defendant is diagnosed with mood disorder and is untreated. What we're going to do is refer him to a hospital or medical treatment facility to medicate and help him achieve competency, and we will receive a finding from that facility as soon as possible, and hopefully the defendant shall become competent and we can move forward in this case. And those findings are made a part of the record for all purposes. Thank you.
Judge, do you want to do this last plea from the trial docket?
Yeah.
It's right here. Ms. Watkins.
Who is it? Who's the attorney?
Stephanie Watkins with Mr. Robin. Your arms. You just need the fingerprint in front of me. You should have them in your view already.
What do you have, Reagan? I'm getting to you. I'm gonna go next. Okay.
Yeah, I did. I forgot to get my client to sign on the just kind of find my signature missing. Oh, she's been talking. She's already. Please raise your right hand. You should not walk right to the football booth and put yourself down.
Simple aside, just say it.
Well, 2 cases, cause numbers 22-40070 and 40075, the state of Texas versus Stephanie Watkins. Are you Stephanie Watkins?
Yes, sir.
Present, your attorney, Ms. Caruso, and the state's attorney. Does the defendant waive formal readings of these indictments? In these cases, can we proceed in summary?
Yes, sir.
In summary, 40070, each of these alleged first-degree felonies. I guess we're not going on paragraph 2.
No, sir.
Okay, just paragraph 1.
Yes, sir.
Each of these alleged first-degree felonies, each of these similarly allege that on or about October 21st, 2021 in Jefferson County, Texas, you committed
In 40070, the first degree felony of aggravated kidnapping. And in 40075, the first degree felony of aggravated robbery. Do you understand what you're charged with in each of these cases?
Yes, sir.
If convicted, you face a term of any term in each case of not less than 5 years, nor more than 99 years confinement or life imprisonment, and a fine up to $10,000 when they assess. Do you understand?
Yes, sir.
Agreements have been reached where you would be pleading guilty, sentenced to 10 years in each of these cases
Yes.
to run concurrently.
Yes, sir.
Is that your understanding?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you in each case what's marked as State's Exhibit 1 here.
Yes, sir. Oh, sorry. Thank you.
You need to sign the bottom of the.
This is the-
Did you sign those documents voluntarily? Understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
The bottom you're signing, it states that you understand everything and you also giving up your rights to appeal if I follow these agreements, which I intend to do.
Yes, sir. Thank you.
All right, State's Exhibit 1 is tendered into evidence in each of these cases without objection admitted.
No objection.
Among other things, these state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God in each case.
Yes, sir.
States Exhibit 1, made a part of the record for all purposes. Pre-sentence reports away.
Yes, sir.
I'm going to follow these agreements and find in each of these cases you are indeed pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case
Yes,
to
sir.
find you guilty beyond a reasonable from State's Exhibit 1. I'm going to follow these agreements. You are hereby found guilty beyond a reasonable doubt of these first degree felonies. And you were hereby sentenced in accordance with these agreements to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each of these cases. They shall run concurrently. Do you understand what has happened today?
Yes, sir.
Anything else?
No, you're right.
That's all. Thank you. Reagan? Yeah.
Thank you.
Who is this?
Clyde Freeman.
Clyde Freeman. I think it's Clyde Eugene Freeman.
It is, that's correct.
Come forward. And
Here, please.
come see this lady. As we call Clyde Eugene Freeman, cause number 25, CR 403.
Yes, ma'am.
The defendant is present with Ms. Manaldi, his attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary
Yes,
fashion?
No, right here. Yeah. Yeah.
Come forward, sir, right there. In summary, indictment alleges that on or about February 21st, 2025 in Jefferson County, Texas, you committed the third degree felony of failing to comply with sex offender registration requirements. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be, whatever sentence shall not exceed a cap of 5 years in prison. So you were looking at no less than 2 nor more than 5 years in prison. And is regular probation an option?
Yes,
So you could be placed on probation, deferred or unadjudicated probation as well. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty, sir.
You pleading guilty voluntarily, that is on your own free will, and because you are guilty. Yes, again.
Yes, sir.
Okay, I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
So,
State's Exhibit 1 tendered, without objection, admitted. All right, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God. The court makes implicit findings that all of those representations are true and correct, and I find them beyond a reasonable doubt to be true and correct. Pre-sentence report is waived.
No, Judge.
It needs to be done. We're going to have a pre-sentence report. We'll return back at a later date.
July 7th.
July 7th.
Okay. All right. Please get a resetting and we'll come back and everybody will add what you need and the court will make its decision then. So good luck. Yes, sir. Edwin Dixon? Is Edwin Dixon?
That was
That was already done, right?
Yeah,
I
sorry.
didn't. Clyde Freeman? I did that one
Just
too.
that, we just did that.
Vanessa Hall,
Judge, Mr. Ham has expressed that he's gonna dismiss that case, but.
24 CR 2, 4, 6, 7 on Vanessa Hall. Is she pleading to anything else? No, that's the only case?
But alcohol has one case to dismissal, Judge.
And I'm signing that at this time. That case is now hereby dismissed. Latasha Hippolyte? Is
She's a
that
plea
right?
judge.
Hippolyte? Is that you?
Yes,
Miss
sir.
Hippolyte? Come on.
Over here, please, ma'am. And please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes. Okay. You got your right thumb on it? And sit flat right there. You can have one, I need it darker than that. You can- And then look, do it right there. You got to do kind of judge. Could you give me Mr. Freeman's file?
Okay. 21-38737 is called the State of Texas versus Latasha Shandy Hippolyte. Is that you?
Yes, sir.
Present with your attorney?
Yes.
And the state's attorney, Ms. Minata, does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes.
In summary, the indictment alleges that on or about June 24th, 2021 in Jefferson County, Texas, you committed theft. Paragraph 2 goes on to allege you have 2 or more prior theft convictions out of Harris County and Montgomery County, Texas. Paragraphs 1 and 2 constitute a state jail felony, which carries with it, if convicted, not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're charged with and the punishment range that could be applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 20 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution here?
No, Judge.
How do you plead to paragraphs 1 and 2, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
And paragraphs 2, which allege those prior convictions in 2016 and 2018 out of Harris County, and then 2019, a death out of Montgomery County, Texas. Are those allegations true and correct as they are alleged?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses.
Totally satisfied with the representation provided by your lawyer? All of this is true. It states by you, so help you God. It's received, made a part of the record, and the court makes findings affirmatively stating that those are indeed, those representations provided by you are true and correct. Pre-sentence report is waived.
Yes, Judge.
I'm going to follow this. If nothing further, I'm going to find you are pleading guilty to paragraph 1, true to paragraph 2, voluntarily, knowingly, intelligently. That's enough to support State's Exhibit 1 to find you guilty beyond a reasonable doubt. I now find you guilty of the state jail felony. I'm following this agreement. You're sentenced to state jail for 20 months. Do you understand what has happened today?
Yes.
You'll be given all time credit for what you have served in accordance with this case. You understand?
Yes.
Anything else?
That's it.
That's all. Thank you. Daniel McCray,
Yes.
what are we doing here?
Simply, Judge.
You need to see me, Judge. Mark, right?
Go see this lady, Mr. McCray. Thank you. 24 CR 245 is going to be called. State of Texas versus Daniel Javon Wynn McCray.
Put the pipe in here.
Are you Mr. McCray? Here with Ms. Minaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary? In summary, this states that on September 28th, 2023, on or about in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with, sir? Yes, sir. If convicted, this is a third-degree felony. You face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached for you to be placed in deferred or unadjudicated probation up to 5 years in length, fine $500. Is that your understanding? There will be other terms and conditions of probation. Is that what you understand is the plan? If I follow this, you have no right of appeal. Do you understand? So how do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes. I show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily? Did you understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence without objection admitted. Among other things, the states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been for you. You read it. You were guilty of a crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Running out of breath. All of this is true. The court finds, and the representations are made. State's Exhibit 1 is made a part of the record for all purposes. I find you are pleading guilty voluntarily, knowingly, intelligently. There is enough supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. I am, however, going to defer any finding of guilt. Place you on deferred or unadjudicated probation for 5 years. You will be fined $500. There will be terms and conditions of probation, which are normal and customary. Make sure you follow these. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in the state jail. You're going to have to also take defensive driving. You understand? Be serious about it. 2 things. It'll help you make better choices while operating a 4,000-pound missile around town, which protects you and other people. Also, you're going to get a reduction on your insurance. So that's a win-win. Okay, please see the probation office. Thank you.
Thank you, Judge.
And I have Jaden Ford. What are we going to do? Hello?
Where else? Lisa, Your Honor, we just got the discovery. The two violations that make up this case are case related, an ag assault and then a tampering with witness.
How much time do you need?
I mean, we're looking at two cases, so I mean, 6 weeks would be great.
Okay, we're going to set this for 6 weeks, what?
Oh, is that for a hearing?
Yeah, on first amended motion to revoke probation. We'll do that, okay? Who's on that?
Danny Boyd.
All right, it's set for them. Thank you.
Thanks.
John West,
Yes,
Zeno Joseph, Justin Manuel.
Maybe it can be reset, or we're still working on that. That's the first time. We're here, we'll get about 4 more weeks.
4 weeks for announcement on Manuel 2393, Zeno Joseph, DWI. What are we doing? MPRP? And let me see the file on Manuel. Does that mean, Zeno Joseph? Who's the attorney on that? State, Jimmy Henry.
well, Joseph.
Who's this? Wait.
Wait.
I had the wrong one.
I'm sorry. Let's switch. This must reset 4 weeks.
Yes. Okay, motion to revoke probation filed in December
On whom?
on Zeno
Oh,
Joseph.
that's different. That's not true.
That's yours, right?
Yeah, I was wrong last year.
Okay.
That's Mr. Boyd's.
Abandoning, endangering a child in Harris County, committing illegal possession of controlled substance. Suspect marijuana, location, okay. All right, when can the state be ready on this one? Who is it?
I wouldn't be ready, right?
Okay. All right, this thing was filed in December.
Right.
We
had-
how long does anybody take? It's
we had-
5 full months have gone by.
Yes.
We had,
I think there was an agreed plea on it.
Plea on it, but you were doing something. It was rejected.
Okay,
So that's
well,
why I had.
we're just gonna have a hearing then. All right. Set for a hearing, when can y'all be ready?
We can be ready, in a week, Your Honor.
What was what was,
180 days.
about the minimum on that?
Yeah, based on facts.
Okay,
And then that's David.
there's no, y'all didn't come back with anything else?
Now, my client wants to kind of explain his.
Okay, all right. All right, that is all. Cullen Cannon,
Yes, sir.
is this the last one?
Yep.
Announcements, right? No.
Judge,
I got 2 cases here that were filed recently.
Yes, sir, and I spoke to Ms. Cannon and got the discovery, but I'm not ready. So I'd like to resetting so I could.
Is 4 weeks gonna be good?
Yes, sir.
Reset each of these 2 cases. 25 CR 399 and 398 will be reset for 4 weeks. Okay?
Yes, sir. Thank you, Your Honor.
Anything else? If not, we're in recess. Here, thank you.